Good morning. The time is now 9:30, and I shall resume this inquiry into the appeal made by Rainier Developments Limited, Samuel Gray. Can all parties hear me? Yes, okay, thank you. By Samuel Gray and Robert Clark under Section 78 of the Town and Country Planning Act 1990 against the decision of Braintree District Council to refuse planning permission for an outline plan application, some matters reserved, for residential development of up to 37 dwellings, including 40% affordable housing, with vehicular access, areas of landscaping and public open space, at land to the west of the A131 High Garrett. This is the second day of the inquiry, and first, please, can the mobile and desk phones be turned off or on silent? On the first day, on Tuesday, I made my opening comments. The appellant and the council made their opening statements. I also gave interested parties the opportunity to make comments, although none had indicated they wished to speak, and also none were in attendance. I then adjourned the inquiry in light of matters arising in respect of how the inquiry was to proceed. I then undertook the accompanied site visits with both main parties, and then also my unaccompanied visit afterwards. As I confirmed on Tuesday, from today onwards, the inquiry will proceed as a virtual event. Also, as I said on Tuesday, as the inquiry is now proceeding virtually, the council will need to compile the attendance list and send it to the planning inspectorate case officer on each day. Today, I will carry out the housing land supply roundtable session and also start to hear from the council's planning witness. That completes my opening comments for today. But firstly, Mr. Williams, is there any housekeeping matters that you'd wish to raise to my attention?
Just to confirm, sir, that as you requested, the council have a room available at its offices for members of the public were they to attend, and the reception knows, if that's the case, to direct them to the room and to direct them to the relevant persons as well. As I understand it, nobody's attended thus far.
Okay, thank you. And Mr. Easton?
Not from me, sir, apart from to thank Mr. Williams and the council for organising that separate room.
Okay, thank you. So I'm now going to move on to the housing land supply roundtable session. The purpose of the roundtable session, that will be obviously led by me, is to invite you to put your points to me by way of questions that I will ask as necessary to inform my decision on the appeal. I have circulated an agenda for the structured discussion which I shall lead on, and which the parties should have to hand. It sets out the matters which are for discussion. I've read the housing land supply proofs of evidence, the housing land supply statement of common ground, the Station Road appeal decision, which the appellant drew my attention to with the council, and also the council's response in relation to the update to the appeal decision, and also the Scott schedules as well that have been submitted. So there's no need to repeat that evidence, although obviously you can draw my attention to them as you answer my questions. Obviously, as I said in my opening comments on Tuesday, I do now have two Scott schedules, and at that point it was established that the difference between the two is an update from the council in relation to its position on the site known as land east of Broad Road. Now, in relation to the council's update to the Station Road appeal, the appellant will be afforded the opportunity to respond to it as we go through my questions. I intend briefly to touch on the matters of agreement before moving on to the definition of deliverable for the purposes of the framework, and then dealing with the 8 sites that are in dispute. We will then deal with the windfall allowance, which is also in dispute, and there will also be an opportunity to raise points in relation to the various other appeal decisions and case law that have been referred to as regards housing land supply. Finally, I will ask the parties to confirm their 5-year housing land supply position post to our discussions. Mr. Williams, do you have any questions at this stage?
No, sir, that's all very clear. Thank you.
And Mr. Easton?
Only this, just you've mentioned a number of the documents, but can I just perhaps run through a list of documents I think we're likely to need, at least as far as the appellants are concerned. There's Mr. Dodd's proof and appendices, Mr. Evans's evidence, the statement of common ground, the council's latest housing land supply statement, which is CD 8.14. The Station Road decision, you've mentioned that already, sir. The council's response to the Station Road decision, which does include the updated Scott schedule, and we may need, I think, the MPPF. There are extracts from the PPG in Mr. Dodd's appendices.
Okay, thank you, Mr. Easton. Okay, moving on to the matters agreement then. Based on the statement of common ground, housing land supply, my understanding is there are agreements between the main parties on the following: the housing requirements, the period for the assessment, completions since the start of the plan period and shortfall, how any shortfall should be calculated and addressed, the council's housing delivery test score and the correct buffer to be applied, how the buffer will be applied, and the version of the council's latest 5-year supply position statement. Mr. Williams, are you in agreement with that?
Yes, I believe that's absolutely correct. I'll just look to Mr. Evans to confirm as well.
That's correct. Yes, thank you, sir.
And Mr. Easton?
So I'm sure that's right, but I'll just ask for a nod from Mr. Dodd.
Okay, thank you.
Thumbs up, that'll do.
Okay, I'm now going to move on to agenda item 3, the definition of deliverable. In terms of specifically the definition of deliverable, which is set out in the framework and further explained in the planning practice guidance, housing supply and delivery, is there anything in particular that you wish to draw my attention to at this stage in relation to the definition itself? Firstly, Mr. Easton.
So I think from here on in, just to explain, Mr. Dodd, I think, is going to be our principal spokesperson. I will intervene from time to time.
Okay.
You can also see Mr. Murray Cox with his camera on. He is there in circumstances where matters outside housing land supply are potentially discussed. I think he will probably not perform much of, if any, of a role, but he's there just in case. So I'm going to invite Mr. Dodd to start off, and if there's anything else I need to add, then I'll do that at the end, if that's okay.
Okay, thank you, Mr. Easton.
Thank you.
So, Mr. Dodd, did you hear my question?
Yes, I did, sir. Hi. So my view on the definition of deliverable is Annex 2 principally in the framework, which tells us for sites to be considered deliverable, they should be available now, suitable for development and achievable, with a realistic prospect of housing being completed on the site in 5 years. Much of there has been previous discussion on case law around whether there's a closed list element of the definition of deliverable in respect of the 2 categories that are identified, category A and category B. I would draw your attention to category B, where for sites with outline planning permission, where they're allocated in development plan or there's been a grant of permission in principle, clear evidence is required to be provided that housing completions will begin on the site in 5 years. I think the Annex 2 definition is supplemented by the PPG, which I've included as my appendix JD1. Paragraph 7 in particular, which is included in that appendix, identifies what could constitute clear evidence for the purposes of category B of the definition. For the avoidance of doubt, I don't contest the concept of whether there's a realistic prospect, and I don't think anything's between us and the council on that. My evidence principally deals with whether there's been clear evidence provided whether the sites are deliverable. And beyond that, what a realistic amount of housing could be provided on those sites, mainly taking into account realistic lead-in times to development and the rates of delivery. I don't think on any site the actual rate of delivery is contested between myself and the council. Going to the amount of delivery that can be seen on sites, I've in my evidence outlined my case on lead-in times, doing a local assessment of the lead-in times to development. Sorry, sir.
Yeah, sorry, Mr. I'm actually going to come on to that shortly. So,
Okay.
yeah. So, so anything further in terms of the definition itself and the PPG that you referred to that you specifically wish to draw my attention to at this stage?
There's one element of clear evidence which relates to the use of pro formas. The council have relied on pro formas provided by developers or promoters to determine whether a site is deliverable in the 5-year period. My case is that in and of itself, a pro forma does not constitute clear evidence that homes will be delivered in the 5-year period. And ultimately, that alongside a pro forma, there should be a realistic assessment taken of the other factors that influence development, i.e. planning status, infrastructure, viability, and I refer to paragraph 7 of the PPG on that point.
Thank you, Mr. Dodd. And the same question to the council. Mr. Williams, is Mr. Evans leading? Sorry, Mr. Easton.
Yeah, so I was just going to add, so I'll put my hand up both virtually and physically. Can I just make 4 short points? The first one of which is that we accept that deliverability requires the exercise of planning judgment, which is essentially whether there is a realistic prospect of delivery within the relevant 5-year period. What we are not claiming is a test of certainty. So you'll be familiar with the case law, where for some time there was a discussion about the evidential burden which was placed upon local authorities, if any. I think we're clear, sir, that we're not suggesting that the local authority need to demonstrate there's a certainty of delivery at any given point or any given amount. The second point is we accept that the categories of deliverable site in paragraphs A and B of the glossary definition are not a closed list. I did say 4 points. I've actually got 3. The third point, sir, is going back to the pro formas. I think, as Mr. Dodd pointed out, pro formas can and ought to be taken into account in determining whether there is clear evidence of deliverability, but they can't, in and of themselves, demonstrate that there is. It's part of a broader suite of evidence that a decision maker, in this case you, sir, is able to take into account before reaching your planning judgment.
Okay, thank you, Mr. Easton. Yeah, Mr. Williams, same question to the council as well. I think first it'd be quite useful again to clarify in terms of what role you're going to play and what role Mr. Evans is going to play.
So on this particular topic, I've got 3 points to make before I hand over on the approach to deliverability and the interpretation of it, before I'd ask Mr. Evans to address what the council's approach has been in this specific case and how it's taken a conservative approach. On the remaining topics, it'll be Mr. Evans leading.
Okay.
So if you're happy, if I can make my 3 points, which will foreshadow what I'm going to be saying in closing in relation to this. The first, and happily there's some agreement with the appellant, it would appear here, is that the operative test within the annex to the NPPF remains the same as the 2012 NPPF. To be considered deliverable, sites for housing should be available now, offer a suitable location for development now, and be achievable with a realistic prospect that housing will be delivered on the site within 5 years. What the 2019 and then now the 2021 NPPF have done is added 2 evidential presumptions to that, A and B, as to when the operative test will and will not be met, but they're not the test itself. They have to be read in light of the operative test. And so my first point is that realistic prospect is what the Court of Appeal in St Modwyn said it was. Not only, as Mr Easton said, did the court say deliverability does not require certainty, they also went further and said it doesn't even require probability, whether more likely than not to come forward. The language is clear. It's simply that there has to be a prospect that housing will be delivered, and that prospect is realistic. And it's that level of probability that one is looking for, and which one must inform one's judgment in relation to this. That's the first point. The second point is in relation to the evidential presumption at B, the clear evidence that housing completions will begin on site within 5 years. And I just stress this, sir, the focus is whether on completions will begin on the site within 5 years, not whether all of the housing in the 5-year supply will be delivered, or whether there's a realistic prospect it will be delivered. And therefore, if you have clear evidence that how completions will begin on site within the 5-year period, you have met that evidential presumption. And then you ask the question, is the number within the supply for that particular site realistic? And just to point out, sir, that when there has been some learning on what the will begin means, and it's quite clear that even that doesn't require certainty. St Modwyn tells us that the planning system obviously doesn't deal in certainties, but the land to the west of Lytton Way, which is CD 6.5, the inspector rejected a contention by the appellant in that case that the phrase will begin requires a guarantee or certainty of delivery. And that has to be correct, given the operative test, as I say, is whether there's a realistic prospect. And then my third point, sir, is to do with the sources of evidence which can amount to clear evidence. And the overarching point I would suggest, sir, is that there is no hard and fast rule as to what can and what cannot constitute clear evidence. It has to be context specific. And a pro forma in a certain case may be very strong evidence of housing completions begin on site within 5 years. For instance, if this is a greenfield site where there is no other complications in it coming forwards and the figure is otherwise realistic, it may be less strong in more complicated sites or where the figure is on its face high. And I'll pass over to Mr Evans now to say it's the case here that the council hasn't simply swallowed what has been said in the pro formas. It has on a number of occasions, and I'll turn to Mr Evans for the detail, reduced the number that has been projected by the developer or owner of the site in line with its own projections. So with that introduction, if I could ask Mr Evans to just speak to the council's approach and how we say the council actually taken a conservative approach in a number of ways to the definition of deliverability.
Thank you, and thank you, sir. I just wanted to first come to a couple of points about the clear evidence test and the NPPG, and then talk about sort of the council's overall approach towards how it's assessed deliverability and sort of the process it's gone through. So first, in relation to the NPPG clear evidence test, as Mr Dodd pointed out, paragraph 007 of the housing supply and delivery section. So the first point I wanted to make is that the clear evidence listed in that section isn't an exhaustive list. I would say that's clear from the words may include, so other types of evidence or other factors are capable of being clear evidence as well where appropriate. And the second point is that the council or a site doesn't have to meet all those tests listed in the listed in that section of clear evidence for a site to be considered deliverable. It might meet some tests, there might be other factors as well. It's not sort of a tick box exercise that a site must have to meet every single test of clear evidence. I'd just like to draw a couple of your attention to a couple of specific points of clear evidence that section of the MPPG raises. And that's the section on current planning status, and it talks about how much progress has been made towards the approval of reserve matters, or whether these link to a planning performance agreements that set out timescale for approval for reserve matters. As well, sort of paraphrasing there from that section. And also the part of the MPPG, paragraph 7, where it talks about firm progress being made towards the submission of an application, for example, written agreement between the local planning authority and the site developers, which confirms the developers' delivery intentions and anticipated start and build out rates. And that, again, that's sort of linked to the pro forma evidence that the council have gathered. So moving on to the sort of the council's overall approach towards how it's assessed the deliverability of sites. In my view, the council have taken a cautious and conservative approach towards what sites we include overall in the supply, particularly from Limb B or Category B sites as set out in the MPPF. For example, we haven't included, there's no allocations in there, or there's no sites from brownfield registers. They're all sites that had outline planning permission as of the base date, or there's a few sites that had resolution to grant and that were where the permission was issued shortly after. And I think the council's cautious approach is clear from one site, well, just for an example, one site that will come on today, Long Green Cressing, where previously the council didn't have a pro forma for that site, and it anticipated, or it just still does anticipate 110 units coming forward from that site in the 5-year supply period. The pro forma we've now received from the developer suggests that they think that the whole 250 can be included. So I think that's just sort of further evidence of how the council have sort of taken a cautious approach, where we haven't had a pro forma from developer. We have generally tried to take a cautious approach.
Okay. Just on that point, obviously I prefer in terms of the specifics for the sites, if we can deal with that later on as we go through the list rather than now, but please carry on.
So yeah, just to give an example, yeah. So just on that point of pro formas, when we've received a pro forma from developer, we haven't just sort of taken it as read. We have sense checked that information and taken a more cautious approach. And so I understand your point you just made about getting onto the site specifics later, but just to give some examples of sites where we've taken a more conservative approach: land off Church Street, High Garrett, Towlands Park, and now the Long Green Cressing site as well. So the developers are suggesting more, and the council have sense checked that and taking a more cautious approach. And in my view, the pro formas are capable of being clear evidence as set out in the MPPG, including from agents or representatives of the site, as well as from the developers themselves. And in my view, obviously that should be supplemented with other evidence as well. It shouldn't be the only evidence, but in my view, that should be considered clear evidence. Just a couple more points for me, sir, and that's the use of the council is using planning performance agreements for a number of sites, and that's one of the tests set out in the MPPG. And again, these provide greater certainty for developers by setting out a timetable for determination of the site and providing the council with the resources they need to make sure those deadlines are met. And lastly, the use of pre-application that the council encourage. So for a number of the contested sites, the council have encouraged pre-application to take place before. And the reason I mention that is for 3 reasons. The first, that it results in a better scheme and application, or that's the idea, and that it will lead to a better scheme and application being submitted. Reserve matters can then be approved more quickly with less need for negotiation and revised plans, and also more likely to reach sort of a favourable recommendation by the officer as well when it goes to planning committee, because it's already been through that pre-app process. So in my view as well, pre-app, the existence of pre-app and that pre-app process is obviously confidential, but in my view, the fact that it's taking place is a positive thing, and again can be considered to be evidence as well that a site is progressing towards the submission and the grant of reserve matters. Thank you, sir.
Okay, thank you. Mr. Easton, do you have any final comments on this, specifically on this question before I move on?
So I just had one response in relation to, I think, the concept that was introduced by Mr. Williams, then picked up by Mr. Evans, that the conservative or cautious approach. Can I just ask you to note this? We have proceeded on the assumption that the local planning authority have applied both the policy and guidance in relation to deliverable sites. We have also proceeded on the assumption that if the council considered that other sites met that test, that they would have included them within the supply. And so we are testing the supply that the council claims will be delivered within the next 5 years. So the extent to which the council has been conservative or cautious, so I'm not sure gets them terribly far in circumstances where we can't examine sites which may have come forward if they weren't conservative. That's my only point. The rest of it, sir. I mean, just whilst I've got the floor, as it were, just for your note, the very helpful summary of the policy position and the extracts from the PPG is contained at pages 15 and 16 of Mr. Dodd's proof of evidence. That's why I think most of the key points are extracted, and it's a useful reference point. Thank you.
Okay, thank you, Mr. Easton. Okay, Mr. Dodd, I'm just going to turn to your proof now. If you can turn to pages 18 to, I think it's 18 to 20.
Yeah, we'll have it, sir.
Okay, thank you. Essentially, they set out an assessment of lead-in times that you've carried out, and you briefly touched on that, I think, in the earlier response to my question as well. I think it'd be useful for you to talk me through how that's being carried out, please.
Of course. So the council, in their topic paper to the Section 2 plan, which is in the core documents at 5.9, CD 5.9, provided an assessment of the time it takes sites to progress from detailed planning permission to completions. I've extended the approach taken by the council and also included the time it takes from an outline planning application to be validated and taken to permission, and then outline planning permission to detailed permission. So essentially it shows the life of an outline planning permission from validation to completions. So the findings of that are obviously that it takes more than 5 years. In terms of the sites and relating to the sites in the council's trajectory, obviously there aren't sites in there. None of the sites I've contested don't have outline planning permission. They all benefit from outline. So it's the later stages of that lead-in times that I think are most relevant to the evidence. I think this applies, well, it's useful to apply it as a benchmark in considering how long it takes from planning permission to first completions. Although I must point out that in the appendix, if you refer to my appendix JD3, you'll see the list of sites. So there's 2 tables in there. Firstly, outline application validation to decision. So that's at the outline stage, and it's the second table that's most relevant, which is outline decision date to reserve matters decision date. You'll see that of the basket of sites that have been considered, there are quite a few that are on the smaller scale. The largest site in there is 665 homes. Comparing that to the sites that the council claim are deliverable at the 1st of April 2021, there's multiple large sites. And I suppose my submission really is that this is a useful benchmark generally, but for large sites and relating to the PPG as well, paragraph 7 again, there are wider considerations for large sites often in terms of infrastructure, complexity, phasing, and so my lead-in times assessment, although the sites in there provide a useful benchmark, it should be considered alongside other evidence on those large sites.
Okay, thank you, Mr. Dodd. And I think the council as well, Mr. Evans, be useful to explain to me, please, that the approach the council takes in relation to its lead-in times.
Thank you, sir. Yeah, so just in relation to sort of leading times and what the council assess, I think we take a slightly different view of it. We don't ignore sort of national data and how long it takes, but in my view, that's of limited use. And as Mr. Dodd sort of alluded to, looking at the process from submission of the reserve matters or validation of the reserve matters all the way through to actually starting on site. The sites we're going to be looking at later in the session today are really far into that process. You know, they've already got outline permission, already into the process of getting reserve matters approved. So for that sort of been the first reason, I think it's of limited use. And sort of secondly, the approach the council takes, which is to look at the sites on an individual basis, I think is the more appropriate one. And that's because we can use the site-specific information as it linked to a planning performance agreement, which actually sets out the timescale for determination of the reserve matters. Has it had pre-app, for example? When were the reserve matters submitted? You can use, but actually looking at the sites individually and looking at the circumstances, I think you can make a much more reasonable estimate of when the reserve matters are going to be approved. Rather than relying on national data and national averages that include sites all across the country from different councils, and you really haven't got any information before. It's quite hard to compare. Obviously, it is an average. But again, when you have the site-specific information in front of you and sometimes planning performance agreements or an indication from the council when actually the reserve matters is going to be approved or go to committee, I think that's a much stronger indication in my view. And the council have produced evidence in terms of its monitoring report, core document 8.14, appendix 4 of that document. The council have done some analysis to show from when when sites have gained detailed planning permission to actually when first completions begin. And that's sort of alongside taking into account national data as well. That is the information the council have used and what we've based our trajectory on and lead-in times on from that period of the site. So first of all, looking actually at the site detail, when is the site going to get detailed permission, and looking at the site specifics, and then using that local data, taking into account national data as well, of the likely lead-in time from the detailed permission being granted to actually completions on site. So that's the way the council have approached it. Thank you, sir.
Mr. Dodd, do you have any final points you want to raise before I move on to my next question?
Yes, please, sir. Just two. I agree with the council that planning judgment should be applied in relation to the lead-in times and alongside site-specific information. And just in relation to the large sites, I think it was alluded to by the council, the infrastructure timings, the planning progress of sites, etc. Are all considerations to that, and I'll come on to those in relation to specific sites.
Okay, thank you, Mr. Dodd. Mr. Dodd, just saying with your proof, this may be a matter of clarification. On page 20, you've got your table 2, which is what's called the Turley lead-in times analysis. On the first line, where it says outline validation to permission, again, I think it's probably a point of clarification rather than a question, but do you mean outline validation to outline permission, or do you mean something else?
Yeah, sorry, outline validation to outline planning.
Okay, thank you. And Mr. Evans, do you have any comments you'd want me to you'd want to raise in relation to that table?
Nothing further to add. So no, just what I was saying before about actually looking at the sites in my view, and their anticipate, is a reserve matter has been submitted, when does the council anticipate it being determined? Has it been through a pre-app? A much more relevant thing to take into account, stronger things to take into account in my opinion, rather than the national averages. I did have a quick point in regard to the large sites, which Mr. Dodd said before, which I forgot to mention. And obviously we'll come on to it a bit more as we go onto the sites, but that's sort of the phasing approach that takes place on the large site. So often the council work with the developers to bring forward a large site in as phases, and quite often the first phase that comes forward is I wouldn't go as far as say easy, but a less complex part of the site, and therefore can gain the reserve matters permission more quickly and start delivering out as well, while the potentially more complex parts of the site come forward. And that's the approach that the council tried to take on its large sites, and it's worked on other sites in the district. I can give some examples if you would like. Thank you.
Okay. Mr. Dodd, I'd also appreciate your comments on that point as well, in relation to the large sites.
Sorry, so in relation to the phasing of large sites?
Yeah, in terms of the sort of the evidence that Mr. Evans just put forward on that.
I mean, there is, for example, would this be a good time to move on to the Land East of Broad Road, where the phasing is a consideration?
I'm going to come well that very, very soon. But at the moment, I'll just prefer to keep it in terms of that point, really, in terms of the more, if you like, the more general point in terms of large sites.
I mean, I suppose my key point on that is it's alongside infrastructure, the timings to receive reserve matters. You have multiple phases coming forward on a site. Using Broad Road as an example, we have evidence of one house builder involved, but a first phase of potentially 300 homes. It may be that the first phase, for example, could come forward relatively quickly, but at the rates of delivery, that means we might, at realistic rates of delivery, we might only have one reserve matters application, one sales outlet, one house builder on that site first, while other phases come forward. And I think it's often a complicated process of bringing forward multiple phases with multiple house builders on a large phased site, and the timings of infrastructure and things are relevant to that consideration.
Okay, thank you, Mr. We will come on to that site very, 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 very soon, in fact. Okay, in terms of the definition of deliverability, and say before we move on to examining each site individually, are there any further comments you'd want to put to me in terms of that definition? Firstly, Mr. Evans.
No, thank you, sir. I think we've covered all the points I wish to make. Thank you.
Mr. Dodd.
I only have one point, sir, which is in relation to pro formas, but I'll come on to that in relation to specific sites.
Okay. Mr. Easton, you have your hand raised.
I do, sir. Thank you very much. This may not be the moment to raise this point, but I know we'll be discussing Station Road in due course. And what will be very helpful to know is whether or not the council, as it says in its response note, disagrees with some of the Station Road inspector's judgments because they consider that he took an overly pessimistic approach to deliverability, or whether their view is that the inspector took a legally erroneous approach. In other words, did not properly understand the legal test, the policy test that we've been discussing so far this morning. There's an important distinction, but it'd just be helpful to know whether it's a question of legal error, i.e. the inspector got the test wrong, or whether the council disagrees with the inspector's judgments in that particular appeal.
Okay, I noticed Mr. Williams has his hand raised. What my intention is, as we go through the sites, where there's the sites which have been raised that concern that inspector's decision, obviously I'm going to give the appellant person, obviously also the council, the opportunity to comment. So that may be the most opportune moments to do that. If we get to the end of that session and the parties feel that that point hasn't been sufficiently covered, then by all means, at the end of it, I've got a kind of mop-up question anyway, where if there are other matters which need to be raised, they can be at that stage. So I intend to proceed on that basis. Okay, well, we are now going to move on to item 4, which is the sites in dispute. My first question is for the council in terms of this site. In the evidence that has been submitted, there's a business being put forward called L&Q. So just really be useful to explain to me who they are in relation to this site.
Thank you, sir. So my understanding is that L&Q are a sort of leading, well, first of sort of, I've looked on their website, and if you Google them, so it says they're a leading residential developer. So they're not just a land promoter, they're a leading residential developer in the UK and have a variety of schemes underway and experience in delivering large sites and infrastructure. In relation to the Broad Road site, my understanding is that they're acting as a master developer. They may well build some homes as well, but they're acting as a master developer, putting in the infrastructure or large parts of the infrastructure, and then sort of selling off the plots or phases to house builders, then to bring the housing forward. But they may well deliver a bit of housing themselves. My understanding is that in this role, they'll act as the master developer, and they are an experienced residential developer as well as other functions as well. Thank you, sir.
Okay, I will come to you in a minute, Mr. Dodd, but I've just got one question following from that from Mr. Evans. Obviously, the column in the Scott schedule says Bellway is in the process of purchasing the site. So I'm kind of interested in kind of what this how the site will be developed in relation to Bellway, presumably, and also this L&Q, which you've just said may themselves deliver some dwellings as well.
Thank you, sir. Yeah, I think that might have been poor wording by me in the Scott's schedule, so apologies for that. I think I was trying to reduce it as much as possible. And my saying is that Bellway are looking to purchase large parts of the parcels of the site. So my anticipation is that they will deliver the first phase, and perhaps we'll come on to that in a little while. But they're intending to, at least our understanding is that they'll deliver the first phase and purchase large parts of the parcels at this current moment in time.
Okay, and what stage has that purchase got to?
It's my understanding that they're negotiating at the moment. I haven't got an exact date for the purchase to be completed, but Bellway have had pre-applications with us on the first phase, and very much progressing towards submitting a reserve matters application for that phase as well.
Okay, thank you. Mr. Dodd, do you have any comments you would wish me to consider on that?
Yeah, so firstly, sir, L&Q are one of my clients. I promote land for them elsewhere in the country. I'm quite familiar with their business model. In some circumstances, they are a master developer, but in my experience, they parcel up land and sell it to house builders for delivery. As far as I'm aware, in the evidence, maybe this is a factual point that'd be helpful for the council to clarify. As far as I'm concerned, the evidence, as we see it, doesn't confirm that L&Q are a master developer on this site. They're in the role of promoter, certainly, but I don't think anywhere it says they'll be delivering the infrastructure.
Okay, thank you. Mr. Evans, do you have any comments on that?
No, please, there might be an omission on my part, and perhaps now sort of had more recent discussions with the case officer and got their understanding of the site. So that's my latest understanding is what I said earlier about L&Q acting as sort of that master developer, and obviously Bellway might come forward and deliver a greater proportion of the site. And they're currently carrying out due diligence in relation to purchasing the site. But that's my latest understanding. Thank you.
Okay. Mr. Easton, you got your hand raised.
I have, sir. And so in response to the last comment that Mr. Evans made, we didn't object to the council producing a fairly lengthy document in response to the Station Road appeal decision, and we'd rather assume that that was the most up-to-date evidence about deliverability of the individual sites that are in dispute. And it's a matter of some concern that Mr. Evans has now said, well, my understanding from discussions with the case officer is that L&Q may well be a master developer. There's absolutely no evidence to that effect. And I'm hoping that we're not going to be provided with additional evidence which has come to light, or which could have come to light and been identified in the written documentation that we could have had a chance to respond to.
Okay. Mr. Williams, you've raised your hand. You're on mute.
Sorry, sir. I don't want to do back and forth between barristers, but the whole purpose of a roundtable is for answers to be given to your question and to elucidate upon the evidence which is provided in writing. Mr. Evans has done that, provided his up-to-date understanding of the position. Mr. Easton can make submissions in relation to the weight that can be given to that, but that is his latest position, and that's the purpose of a roundtable, sir, in response to your question. It's perfectly proper for Mr. Evans to explain his understanding based on his discussions with the case officer responsible for the site, and then in response to your question, sir, provide that to you.
Okay, thank you. Mr. Evans, I noticed that on some of the sites that we'll come to, and again, it's something that you've mentioned in an earlier answer, the council sets out that it takes what it considers to be a conservative position with regard to the trajectories that the developer or agent puts forward on the pro forma that are submitted. I think specifically in terms of this site, it'd be useful for you to explain to me whether or not that same approach has been taken.
Thank you, sir. I believe it has. The council obviously wasn't before the Station Road decision included 320 units in response to the information we had the agent on behalf of L&Q. In the trajectory, we didn't seek to increase it. We sense checked it and thought that was a reasonable and cautious approach. Obviously, things have developed since then. As of a few days ago, we've had a revised pro forma from L&Q themselves, which set out 270 to be delivered in the 5-year supply period. Again, the council have sense checked this, and we think that 270 is reasonable. And as we'll go into the site in a bit more detail, the council considers that it is a realistic prospect of those 270 units being delivered. And just to make a further point, the council have actually removed those 50 units from the supply for this appeal. So taking on board that latest evidence from the developer and taking a cautious approach in removing those units, where, for example, another site will come on to Long Green Cressing, we had the opposite, where the developer said we think we're going to deliver more, and the council aren't anticipating to increase the units on that site. We're happy to keep it as we had it originally in the trajectory. So I think that's further evidence of the cautious approach we're taking. Where there's evidence of there's slippage, we're actually taking that on board and removing units. But when there's actually evidence of a site progressing faster, or the developers thinking they can deliver faster, we're still taking the cautious approach. Thank you.
Okay. Well, in terms of what you've said there, in terms of that trajectory, what have you had regard to in terms of coming to that the position in terms of the 270?
So obviously, L&Q's estimate themselves as the master developer, and their knowledge of the site and how they plan to bring the site forwards, and obviously pre-applications with Bellway, who we anticipate will deliver the first phase of the site. So those pre-app discussions, and also anticipating the reserve matter submission early next year. Might move on to the infrastructure a little bit later, but the council's view is that the infrastructure can be delivered in a timely manner with that first phase, which is being accessed off an easier access than the main bit of infrastructure, which I can come on to in a little while. Therefore, it allows the site to be developed, first them to get on site and start site work quickly, and also start producing completions on that first phase before the main infrastructure and access is required. And also sort of based on our experience of lead-in times on other sites, and also delivery rates on other sites as well, we consider their trajectory as set out in their updated pro forma is reasonable and realistic. Thank you, sir.
Okay. Mr. Dodd, again, I'd be interested in your comments in terms of the trajectory that the council has put forward in relation to this site.
Yes, of course, sir. I mean, fundamentally, I think the council have been the opposite of conservative on this site, and I don't think the trajectory is reasonable or realistic. The previous pro forma was relied on at face value, and then has subsequently been revised. So it was previously from Barton Wilmore on behalf of L&Q, and now the pro forma is on behalf of L&Q, well, on directly from L&Q. Neither of these are from Bellway. The site, there's no evidence of the site being sold to Bellway. They may have had a pre-app, they may be in negotiations, they may be agreeing terms on the site, but we've got no evidence that they actually have. In terms of the timings for delivery, for example, previously the council had suggested that the application would be within 1 year. As out of my evidence, I thought that was patently unrealistic given the timings that are actually involved in determining reserve matters, starting on site, and it's contrary to the council's own evidence. We've now had a revised trajectory, which they state a reserve matters application. So this is in the appendices to the council statement, which I think was the inquiry document 1, possibly. The updated pro forma from L&Q suggests an application of reserve matters within 1 year. So that would be winter 2022. Then on the council's own evidence from reserve matters permission to first completions, that would be at least a year from then, which is 2023, 2024. So even on the evidence that the council have submitted, the current trajectory is unrealistic and unachievable. And it's for this reason that I don't think we can rely on a developer pro forma as clear evidence that this site will deliver.
Okay, thank you, Mr. Dodd. Mr. Evans, one point you made earlier when you answered my question, you referred to the infrastructure that the site requires to be delivered. I wonder if you could talk that through me, please, in relation to the trajectory that you've put forward.
Thank you, sir. Yeah, could I just address the point of the pro forma beforehand,
please.
If that's okay?
Yeah, okay.
Yeah, so just in relation to the revised pro forma we have, it is a revised. It was the same pro forma, they've just updated it, and my understanding is within the 1 year might be a sort of a hangover left from the previous version. My current understanding is that the reserve matters, or L&Q, who are in consultation with Bellway, and our understanding is that it will be early next year, not sort of in a year's time. And obviously within 1 year is a bit ambiguous, so apologies for that. But our latest understanding is, as I think I set out in the Station Road Notes inquiry document 1, is that reserve matters will be submitted early next year and dealt with fairly quickly. It'll be for the first phase, and it'll be dealt with through a planning performance agreement. Bellway and ourselves are keen to use that, and there is also a site-wide design guide in place at the moment, again which will aid the speedy determination of the reserve matters. So moving on to your question on infrastructure, so it might be helpful to turn to inquiry document 1. I think I included a phasing plan of Broad Road, the actual site.
Okay.
So I see phase 1 is anticipated. So in relation to infrastructure, in my mind, there's two sort of big bits of infrastructure, both related to highways here. The first is the roundabout to access the site off the A131. So if you look at the phasing plan, so there's sort of two roads coming up to make a triangle. The road on the right is the A131, and on the left is Broad Road. So in my mind, that's a key bit of infrastructure, the roundabout to access the site. However, as you can see from Broad Road, there's the part of the site that there's a small red edge that meets Broad Road, which links into phase 1. So the developer can access phase 1 on the site from Broad Road. so they're not reliant on the roundabout, and they can start work on construction on phase 1, and they can have 100 dwellings occupied before that roundabout needs to be constructed. And just sort of a wider point on infrastructures, the council have been very careful when drafting Section 106 agreements. Is yes, we want to see the infrastructure come forward in a timely manner, and that's part of the reason for allocating large sites. But we've been very careful to enable the site to come forward and at least start work, and in lots of cases, as we've here, actually start having dwellings occupied before that infrastructure is delivered, and that's very much been done on purpose with the consultation of the applicants as well. So we've been very mindful of that. So as you can see, they can access phase 1, they can have 100 completions there before the access roundabout is completed. The other bit of sort of key infrastructure I would say is a roundabout further south along the A131, which are roundabout upgrades where the A120 meets the A131. And that's a fairly big roundabout upgrade. However, it's very much the developer that will be delivering that upgrade, so they're not reliant on a third party, Essex Highways, for example, to deliver that, which they have no control over. They'll be delivering it themselves, obviously with an application from Highways. And the plans for those works have, in principle, have already been agreed between National Highways, the County Council and Braintree and the developer as well. So those works have largely been agreed. They do have to have that work completed before occupations take place, but they can access the site from Broad Road and actually have, the site under construction and dwellings well underway under that construction process before that work needs to take place. Just one final point, sir, is that Gallagher Homes, who got the outline, who later got merged into L&Q, they'll very much be aware of this infrastructure requirements, and had through Gallagher, when they were Gallagher Homes, would have had some input and obviously signed off the Section 106 agreement. So I think I would suggest, sir, that the pro forma which they've submitted, they'll be clearly aware of the infrastructure requirements and their plans for delivering them at sort of L&Q this is. So they'll have factored that into the pro forma, and they consider that they can have those completions take place alongside delivering the infrastructure. Thank you, sir.
Okay. Mr. Dodd, do you have any comments in relation to the infrastructure matters which Mr. Evans just raised before I move on to my next question?
Yeah, I was going to raise something different, sir, but on the infrastructure, as I've said, we don't know whether L&Q will be delivering the infrastructure. Again, that's not in the evidence, and they will have had regard to it. But ultimately, as has just been alluded to, their pro forma is simply a best guess at when things will be delivered, because as we've just heard, there are multiple components that are out of their control. On the reserve matters, we don't know what form they're going to come in. We don't know how many reserve matters there will be, whether, how many homes there'll be for, which phases are being acquired by Bellway or other. And I was going to refer you to the Station Road decision, sir, but I'll let you continue with your question.
Okay, fine. My next question is for you, Mr. Dodd. Just get on to page 24 of your proof. Paragraph 7.10. You list there, and again, this is obviously under the Broad Road heading in your evidence. You list there what you consider will need to be, the following will need to be undertaken before completions will be seen on this site. I just wanted to, again, maybe it's more of a point of a clarification, that is this a specific list for this site, or is it of a more general nature?
It's of a more general nature, but it's completely applicable to this site, which has been promoted and is now being sold. So it's an outline planning permission, which has been promoted by a land promoter and is now being sold to a house builder. So I believe all of these steps are required to bring forward homes in the site.
And Mr. Dodd, one thing I do notice you raise there is just on point your second two in terms of the Roman numerals. discharge pre-commencing conditions, including surveys if required. When you say surveys, what do you mean by that?
Any additional surveys required for pre-commencement conditions. So often pre-commencement conditions for a large site like this will require further surveys, possibly in relation to ecology, archaeology, various areas, potentially in traffic. Yeah.
Okay, but again, I'm just trying to clarify: is that specifically in relation to this site, or is that a more kind of general point in terms of, you know, sites which come forward may need that survey work doing?
That's a more general point.
Okay, thank you. And Mr. Evans, I'll be interested in your views on that in relation to what you need to consider will need to be undertaken before completions will be seen.
Thank you, sir. Yes, I have the sort of the outline decision in front of me, so I'm happy to run through the conditions. There are quite a few there, as you might imagine, for a large site, but sort of in my view and in the view of the sort of chatting to the case of, there's nothing abnormal there that you wouldn't expect to see on a large site that in our view will sort of delay the site. And just in respect to that as well, obviously L&Q are an experienced master developer, Bellway Homes are an experienced national developer. These are all, you know, pre-commencement conditions are all, and survey works are all the things they're very experienced with dealing with. They can come forward simultaneously with the reserve matters application as well. If there's not like a strict order which they have to be done, things can be done simultaneously and won't necessarily lead to sort of delays happening. L&Q obviously are aware of all the conditions they have to meet and factor that into their trajectory, and the council considers that's reasonable as well. So just one point I forgot to mention, sir, was that you might have picked it up that phase 1 is 306 dwellings. So the council and L&Q suggestion of 270 in the 5-year supply period can all come forward in that first phase. So that was a point worth noting. Thank you.
Okay, and just on that, sorry, before I go back to Mr. Dodd, what survey? I mean, in terms of the surveys which might be required, can you give me an indication of what that might be for this site if that is the case?
Yes, I'll just have to bring up the outline
Okay.
permission if you bear with me.
So with that, sorry to jump in without putting my hand up. Is it? I don't think we've got a copy of the plan.
I don't think we have either, Mr. Rees. I was going to suggest, Mr. Evans, that this submitted as an inquiry document.
So don't have a problem with that. I think it might be useful.
Yeah.
So just to confirm, so the outline decision.
Yes. Yeah.
And would you like the Section 106 agreement as well?
I think both documents would be useful. Yes. Yeah.
Okay. Thanks. I'll make sure they're submitted. So one of the so I know it's not related to surveys, but one of the conditions which they've already discharged was the submission of the phasing plan, which we've been looking at. That was one condition which they've met. I've just got the decision open now. Tree surveys are one. Construction environmental management plan. Ecological survey updates. So it runs to about 20 pages, and I'm just going through them. Those ones I've picked up so far in terms of surveys.
Okay.
So it might be helpful if Mr. Dodd, if you have any particular pre-commencement conditions that he considers were a problem. Obviously, the outline permission being a public document. I don't know whether, in response to your question, it seemed to be that it was a generalised point rather than a specific condition that's going to cause, in his view, an issue on this particular site. So do I understand Mr. Dodd's evidence correctly?
I mean, Mr. Dodd, first, I think, have you, in terms of producing your evidence, have you had sight of the outline planning permission?
Yes, I have. Yeah, and
Okay,
I have
fine.
submitted in my evidence. I don't submit that there's any pre-commencement conditions that are specifically going to hold up
Okay,
the
fine.
site. I in my evidence, I just submit that it's part of a long process, essentially, to bring forward what is quite a complex site.
Okay, thank you. That's useful clarification.
Thanks.
Thank you. Now, I'm now going to turn to in terms of this site anyway, the Station Road appeal decision. Obviously, this is one of the sites which features in it, and obviously in the council's documents at the end of last week. So firstly, Mr. Doll, I'll be keen to hear your views on it in terms of specifically this site.
So essentially, I don't think anything's changed since the conclusions of the Station Road inspector on this site. I think the Station Road inspector was right to conclude there isn't clear evidence that homes will coming forward in the 5-year period. The Station Road inspector considered the uncertainty around the completion of the purchase of the site or the timings for a reserved matters application. That's at paragraph 49 of the decision. The council have provided the final sentence of that paragraph. The inspector states there's uncertainty around infrastructure and its dependency. The council have, in their updated statement, provided some information on that point. But generally, the conclusions of that inspector, and particularly in paragraph 50, they've considered a pro forma that was not completed by the developer currently purchasing the site. And that's still the case now, because although previously it was Barton Woolmore on behalf of L&Q, it's now still L&Q who are not the developer who are developing the site. And therefore, I stand by the conclusions of the Station Road inspector, and I think the inspector took the right approach to this site in removing it entirely from the supply. Well, not entirely from the supply in that case, but concluding there was insufficient clear evidence on the site's delivery.
Okay, Mr. Easton, you have your hand raised. I was just going to ask Mr. Dodd whether or not I wanted to also comment on the council's evidence at the end of last week. But if so, I think Mr. Dodd, if you could comment on that. If there's anything additional you want me to draw to my attention in relation to that document over and above the appeal decision, then I'll come to Mr. Easton afterwards.
As I've said, essentially, I think the council's updated evidence on the site doesn't add anything beyond the conclusions from the Station Road inspector. There's some clarity on the infrastructure, but I'd considered that infrastructure in my evidence, and therefore I stand by the conclusions of my evidence on the site.
Okay. Mr. Easton, do you wish to make a point?
I do, sir. I'm returning to the point I made earlier on. Now we're talking about the Station Road appeal decision. I'll just briefly raise my point again, and it's this: is whether or not my understanding from the council's response note to the Station Road decision is not that they're claiming that the inspector misunderstood the policy or committed a legal error. It's just that they disagree with the judgments that the inspector made in that particular decision. I would also just note, sir, that at that particular hearing, we know that Mr. Evans gave evidence. We also know that the documentary evidence, albeit updated to a certain extent for this inquiry, was the housing land supply assessment with the base date of the 1st of April 2021, which is CD 8.14. But it's really just to assist you and us, I just would like some clarity as to whether or not it's a difference of judgment that the council rely upon in coming to a different view about the Station Road inspector, or whether they claim there is some more fundamental error in the inspector's approach in Station Road.
Okay, thank you, Mr. Easton. The council wish to respond to that? Mr. Evans or indeed Mr. Williams?
So I think it's a point for me. With respect, it's a mixture of both. I probably doesn't provide the clarity my learned friend would want. It's certainly the case, we say, that in a number of occasions, including on this site, that the inspector took an inappropriately strict approach, in our view, as a matter of judgment. But there are, in certain instances, errors that potentially go beyond that. Of course, the permission was refused in this case, so it's not a case where it would be challenged under a 288. But for instance, in DL 54, the inspector talks of the need for there being substantial evidence, which is clearly not the test to be applied. Nor is there, for instance, in relation to Towlands, any reason why the inspector appeared to disregard the timetable within the planning performance agreement, which is seems to be leaving count of an obviously material consideration given the PPG. So there are some concerns we had as to whether the inspector properly understood the test and properly took account of all material considerations. But our main point is the inspector simply applied a inappropriately strict approach.
So I'm so sorry, sir. I got sorry to interrupt. You dropped out very briefly after you mentioned paragraph 54, Mr. Williams. So I didn't get the follow-up point to that.
The follow-up point, the second potential legal error, Mr. Easton, and you'll know that, as I say, this isn't the case that we're going to be seeking to challenge because permission was overall refused. But the second potential legal error was a failure to take account of an obviously material consideration in relation to Towlands Park because the inspector appeared to disregard the details of the PPA, which set down a timetable for submission. Obviously, that is something that PPG, which is an example of clear evidence. The inspector, it's not clear why the inspector chose to disagree with that. But that's putting that to one side. Our main point is the inspector simply applied a too strict test to the question of realistic prospect of delivery. And it should be applied in the way that I outlined earlier today, and I'll repeat in closings.
Okay, Mr. Easton, do you have any further comments on that before I move on?
Well, so that partially answers my question, but I mean, I'm not going to get any more detailed explanation, and it helps me understand, particularly when I'm coming to closing, where the council's position lies. So that to that extent, it's helpful. Okay,
thank you. And in relation to this site, Land East to Broad Road, Mr. Evans, do you have any further comments?
So can I just make one comment before Mr. Evans deals with the detail on Station Road? Just a point of clarification. As Mr. Evans pointed out in the rebuttal note, the dispute at that hearing wasn't whether Land East to Broad Road was deliverable at all, which is the dispute between us here, but whether the full 320 that was being relied upon was deliverable, as the council said, or whether 160 units were deliverable, as the appellant in that case said. That was the dispute that the inspector in that case was seeking to determine, and she came down, or he came down, sorry, I don't know, on the side of the appellant in that regard. So, but what the inspector didn't do was to say that this site would deliver nothing within the 5 years, which is what, of course, the appellant seeks to say. That's just to frame the issue, sir. And if I could just pass over to Mr. Evans to explain what further information you now have in front of you in relation to this matter.
Thank you, sir. Yeah, so in regard to what's moved on since the Station Road appeal, obviously the inspector there had concerns around the infrastructure. The same level of detail wasn't provided in that sort of hearing as it has been to this inquiry in terms of the documents and what we've been through in terms of the infrastructure requirements. So I believe the council have gone some way to addressing the concerns. The council have also gone and got a direct performer from L&Q, which I know John Bellway. We're not anticipating them to deliver the first phase, but they will be delivering some of the infrastructure. Our current understanding is, obviously, that's up to date as of a couple of weeks ago, if not less. So I believe both those factors have gone some way to addressing the concerns. The council have also reduced the supply in, as Mr. Williams said in the Station Road appeal, the appellants were saying 160, the council was suggesting 320. It was both the appellants and the council considered that the site was deliverable. It was just a matter of how much was coming forward. Obviously, for the reasons the station road inspector set out in the decision, the inspector agreed with the appellant's 160 on that basis. However, I think the council have now put forward the infrastructure requirements and updated pro forma and the information to suggest that actually 270 is reasonable. Thank you, sir.
Okay. Mr. Dodd, do you have any further comments before I move on this site?
Yes, sir. I mean, the council revising the position from 320 to 270 just shows the lack of reliance you can have in the developer pro formas. That's happened within a period of 3 to 6 months. In the next 3 to 6 months, who knows, maybe it will be reduced even further as the site progresses or doesn't. There's multiple uncertainties in relation to the timing of the reserve matters. We don't know firmly who will be developing the site. We don't know who will be delivering the infrastructure. And as I've said, I think the Station Road inspector concluded there was no clear evidence rightly, and there's nothing significant enough that's come to light since that either changes my evidence or shows that inspector took the wrong approach to the site.
Okay, thank you. I'm now going to move on to the next site, which is land adjacent to Blamsters Farm, Mountain Hill, Halstead. And my first question is for the council. On page 8, Mr. Evans, of your evidence,
Sorry, so is this, just to clarify, is this the original evidence, not the inquiry document one?
Yes, your proof, yes, the original evidence, yeah.
Yes, I have that, sir.
Okay, I think in your commentary there, you refer to pre-application discussions and the submission of a detailed planning application. When you say detailed, just to clarify, do you mean a full application or do you mean a reserve matters related to the outline permission?
So I've said detailed to cover both eventualities, sir. So it might be reserve matters, or it might well be a full application. My understanding is it could go either way at the moment.
And Mr. Dodd, do you have any comments on that?
Yes, I do. I mean, that referring to my evidence, that is exactly the sort of uncertainty that the definition of deliverable is designed to consider. We don't know what form the application is going to come in terms of a reserve matters or a full. We don't know who's going to submit the application, when they're going to submit the application, for how many homes it's going to be for. There is just insufficient evidence on this site that it's certainly not clear when and how much development will come forward. As I've said in my evidence, the outline was granted on behalf of an investor, it appears, who are not house builders, and so there will be some sort of process that needs to go on in terms of marketing and selling to a house builder, but we've got no firm evidence before us onto who that will be, and yeah, my position is as in my evidence.
Okay, thank you. Mr. Evans, I think it'd be useful to talk me through the council's trajectory for the delivery of this site.
Thank you, sir. So I know there is some way to go still for this site to get detailed planning permission. We have had pre-app discussions with a medium-sized developer for the site, so things are clearly progressing. We are anticipating that will result in either a full or a reserve matters application, but the actual principle of development on the site has obviously been established through the outline. In terms of the trajectory, I think the council have obviously it's only a small greenfield site of 25 units with a specialist element. So we're not talking about a massive site here. It's relatively small in comparison to the sites we're talking about today. And the council have, as you can see from the trajectory, do say that all 25 units will be delivered in the 5-year supply, but towards the end of the 5-year period, obviously going to the end of March 2026. So in my view, there's clear evidence of the site progressing in terms of the pre-applications taking place. And I think the important context here is it being a small, unconstrained greenfield site. There's ample time for the site to go through the detailed permission process and deliver those completions. So even if it weren't to get permission for another couple of years, I still believe it would be capable of delivering all those completions within the 5-year period. And thank you, sir. I think there's more the point about it being relative to actually the size of the site. I think has to be taken into account when we look at these things. Thank you.
And Ms. Dodd, I'd be interested in your views in terms of, you said in terms of lead-in times and also the council's trajectory on this.
Yeah, so first of all, you can only really undertake a realistic assessment of lead-in times to first completions when you have some sort of detailed planning permission. We don't know when that's going to be submitted. So essentially, any timings that anyone puts forward in relation to this site are a guess, because we don't know when the planning permission is going to come in. My second point was just going to be in relation to pre-apps and PPAs. And the relationship to the PPG and clear evidence. Obviously, there may be PPAs and pre-apps being undertaken on some of these sites, and it's a wider point on the council's evidence. Obviously, there are commercial sensitivities possibly with some of those, but they aren't provided in the council's evidence anywhere, PPAs or the outcomes of the pre-apps. I just want to point out that it is possible to submit a pre-app on a site and have a negative response. And if a developer has acquired this or is intending to acquire this site and develop it, it is a possibility they submit a pre-app for, a different form of development, more units, and that could come back negative. And it may be there are pre-app discussions going on, but I don't believe that a pre-app just in and of itself that we haven't seen is sufficiently clear to determine when homes are going to come forward in the 5-year period.
Okay. And Mr. Evans, on this site, is there anything further you wish to draw my attention to?
Just if I could come back briefly on that pre-app point, sir, if I may. Yeah, I understand the point. We aren't unfortunately able to submit all the details of the pre-application I'd like to, but unfortunately it's a confidential process. But I think looking at the MPPG, it recognises progress towards the submission of an application. I believe this is reading between the lines. A pre-app is one of the things it's talking to. It is working towards the submission of an application. And just to Mr. Dodd's point around, there can be negative pre-app responses. Yeah, I accept that, and I think that's in some ways a good thing that you get the negative issues out, whether it's design, etc. Those are discussed during the pre-app. So when an actual detailed permission, reserved matters, for example, is put in, those negative aspects are removed and a better application comes forward. That's the whole point of doing it. Thank you, sir.
Thank you. And lastly, Mr. Dodd, specifically on this site, is anything further you wish to draw my attention to?
No, sir.
Okay, thank you.
So sorry,
Mr.
sir,
Easton.
it'd just be useful. Yeah, I was going to invite Mr. Dodd's comment in relation to this. One of the things that Mr. Evans said about this particular site is that it's a small, unconstrained greenfield site, and so he didn't consider that there being particular issues in including within the 5-year supply. I'd just like Mr. Dodd's comment as to whether or not the fact it may be a small and constrained greenfield site, is that insufficient? Is that sufficient in and of itself to demonstrate this clear evidence that houses will be delivered within the 5-year period?
No, sir, I don't think it is. It has a principle of development agreed. Ultimately, it's got an outline planning permission on it. So the point that it's unconstrained is irrelevant to whether clear evidence is in place to rely on it within the 5-year period.
Okay, thank you. And Mr. Evans, do you have anything specifically on that point before I move on to further to add?
Yes, so my point, and apologies if I didn't put it across sort of clearly, was I think it's relative to look at these things, such as the size of the site. Is it constrained? Is it greenfield, brownfield? So a point sort of wasn't that's enough for it to be considered deliverable. It's a relevant factor, and these are relative things to take into account when you're looking at. So it's a realistic prospect that a small greenfield site can be delivered within the 5-year supply by the end of March 2026, and the type of evidence you'd expect to see for there to be a realistic prospect of that happening. Thank you.
Okay. Again, Mr. Anything further? You say you don't need to repeat what you said already on this side before I move on. Thank you. Okay, I'm now going to move on to land between Long Green and Braintree Road. Long Green.
So perhaps I could start on this site because my position has changed since exchange of evidence.
Okay, by that clarification first, Mr. Dodd, that would be useful.
Yeah. So my position on the site has changed since exchange of evidence, as I said, and that is taking into account the evidence put into the inquiry by Mr. Evans at the weekend on the reserve matters application that's been submitted by Persimmon Homes. Okay. So previously, when I prepared my evidence, there wasn't a reserve matters application on the site. It was simply an outline permission, and now there is a reserve matters application. That doesn't though change my position in terms of I do think there should be a reduction in delivery from this site, and my proposed alternative trajectory is instead of 0 delivery in the 5-year period. It is to push back the council's trajectory by 1 year. So if you have a trajectory to hand, that is 10 units in 2024-25 and 50 units in 25-26, which is 60 homes in the 5-year period from me. And that's a reduction of 50 homes from the council's anticipated delivery of 110.
Okay, Mr. Just to clarify, so the red figure at the end of table 7 in your proof on page 27, if you've got that to hand, that's rather than saying that should now say -50.
Yes, sir.
Okay, thank you for that clarification. Mr. Evans, obviously, I'm aware now that the reserve matters application has been submitted, but what progress is there with that application?
So thank you, sir. So it was submitted fairly recently, a month ago, the 25th of October. So obviously it's been validated, case officer's been assigned to it, and a planning performance agreement is currently being finalised. So in terms of the projection for when that reserve matters application will be determined, my understanding is somewhere between February and April. That is the current time frame we're looking at for determining it. You might have noted from the updated pro forma we've got on this site from Persimmon Homes, they're saying February. The council are thinking probably more the it's doable, but that's probably more the optimistic side of what we're looking at. We're thinking between February and April would a committee date between then would be realistic in terms of it being determined.
Okay, thank you. Mr. Dodd, do you have any comments on that?
A couple, sir. First of all, obviously the reserve matters is in, but as far as I could tell, there's no comments on it in terms of consultees, and in terms of the acceptability of that reserve matters, there is some uncertainty. I mean, I haven't reviewed the reserve matters in detail, and I don't think we should predetermine the outcome of the council's development management team. But I do think a determination period being put forward by early next year is optimistic for a major reserve matters application. I think it could take more time to determine than that. And I think subsequent to that, once it is approved, there'll be a lead in time from its approval to first completions. We don't know how long the reserve matters will be in the process for. I think it's highly optimistic to just say it will be approved by this point in time. I know the PPA might say that, but in PPAs you generally don't agree timescales that are longer than the statutory determination timescales for applications. So that's always going to state the minimum. In practice, it takes longer. There are uncertainties and usually issues with reserve matters applications in terms of revised drawings and the details. Fundamentally, the key change in my position is that I think there is evidence now to say that this can deliver in the 5-year period, but it's just a revised lead in time to first completions, given the uncertainties and the recent reserve matters application.
Okay, Mr. Dodd. In terms of those revised trajectories you put to me, is anything further you wish to draw to my attention in terms of the factors you've had regard to?
No, sir.
And similarly, Mr. Evans, I'll be interested in, again, any factors you wish to draw my attention to in relation to the trajectories that the council's put forward for this site.
Thank you, sir. Yeah, so just going to make a comment on the PPA point is that obviously the purpose of the PPA is to fund the council appropriately to deliver in those timescales, and obviously there is some negotiation going on with the determination date, and there'll be a financial incentive for the council to meet those deadlines as set out in the PPA. Just in terms of other factors, as hopefully be aware of, sir, we've received a pro forma now from the developer of the site who are submitting the reserve matters, Persimmon Homes. And that is, so I haven't got the appendix number to hand, but it's an appendix in inquiry document 1. And that shows a much more ambitious timescale for delivery. Actually, all 250 dwellings being completed in the 5-year supply period. I think it's realistic. I think they could do that, given the experience on other sites. It's being a greenfield site, 40% affordable housing, so 40% will be handed straight over to or purchased by a registered provider. Only 60% will go onto the open market. However, I'm not proposing to increase the trajectory at all. I think keeping it at 110 is consistent with the council's conservative approach. I think that's all my comments. Thank you, sir.
Mr. Dodd, do you have any further comments to make on that?
Could you just direct me to where the Persimmon pro forma is?
It's one of the appendices to the evidence that the council submitted at the end of last week.
Sure.
Appendix 4.
Appendix 4, yeah.
4.
Sorry, I'm just trying to find it. I have a different pro forma there.
It's Appendix 4.
To the council's response to the Station Road decision.
Yeah, I mean, mine is named pro forma for land between Long Green and Braintree Road from Persimmon Homes, and I understand it was received on the 18th of November this year.
Yeah, bear with you. I'm just bringing it up digitally. Yeah, I have it. So just to confirm, Persimmon in that pro forma say they're going to deliver 63 homes in 2022, which is obviously essentially a month away. Just in relation to the trajectory, I think it's absolutely right that the council haven't relied on this pro forma because it's obviously unrealistic in terms of the timings which they think it's going to deliver, and the delivery rates do look high, and this relates to comments on the wider use of pro formas, I think, in the use of clear evidence essentially, and the reliance on those timings. I think the council are right to disregard it, and then my evidence is related to our realistic lead-in times.
Mr. Evans, do you have any comments on that?
So yeah, just to clarify, the 63 units Persimmon show are in the 22-23 monitoring year, so to be delivered by the end of March 2023. And also just I'll say the council haven't disregarded it, that we've obviously had regard to it, and again I think it's doable given other sites in the district, but the council are taking it, at this late stage. We only received it recently. We're not proposing to change it for the purposes of this inquiry, so taking a conservative approach. Thank you.
Okay, thank you. Mr. Dodd, again, this site was one of the sites which featured in the Station Road appeal decision, and obviously we've already touched on, what the council said about it in the evidence it submitted at the end of last week. But I would be keen to hear your views, I guess, particularly in relation to the appeal decision itself, in relation to this site.
Yes, I mean, fundamentally, the Station Road inspector didn't have sight of this reserve matters application, and that's reflected in the conclusions in the appeal decision. So I think there is a change in circumstances. I agree with the council. There is a change in circumstances on this site from the Station Road inspector, because there is new evidence in the form of reserve matters application, which wasn't considered in that inspector's conclusions. And that is also the reason for my change in position.
Okay, thank you. And Mr. Dodd, finally, on this site, is anything further you wish to draw my attention to?
Just in relation to my lead-in times assessment, or the council's lead-in times assessment at the same time, which is that it takes at least a year from detailed permission to first completions on site, based on the track record in the district. So given there's some uncertainties on the timescales for determination of the reserve matters, I think it's a cautious approach should be applied, which I think I've done in my revised trajectory.
Okay, thank you. And Mr. Evans, anything further on this site that you wish to draw my attention to?
Thank you, sir. Yeah, just in relation to the Station Road appeal, from my reading, I would suggest that the inspector's concerns on that site, mainly that there not being a reserve matters submitted and nothing from the developer, the council have now addressed those concerns. And just a wider point around the submission of reserve matters, that obviously since it's a change in landscape, so since the hearing sat for the Station Road appeal, obviously for two of the sites we've now had reserve matters in since, so things do change very quickly. And finally, just in terms of lead-in times, and it's probably a point I should have made earlier in regard to sort of the council's evidence, that we have produced averages, but again, I think it's important to consider site-specific details when looking at those averages, and those averages shouldn't just be applied blindly. So those averages we've created do include, for example, highly constrained brownfield sites, so the lead-in times on those are much longer. Sites where there are specific issues as well, leading to longer delivery times. So for greenfield sites that aren't constrained, it might be appropriate in certain cases to think that a site could deliver a slightly better than that. So it isn't. And for example, if we're looking at a highly contaminated brownfield site at the moment with loads of constraints on uses that need to be taken off, excuse me, obviously we would all be looking at a longer lead-in time than the average, and that would be right to apply. So I think it's right to look at site specifics as well as using those averages. Thank you.
Okay, and finally, Mr. Dodd, really specific in relation to this site, anything you particularly wish to draw my attention to?
Sorry, sir, just to pick up on a point on the lead-in times, my understanding of the council's lead-in times work is that it is majority greenfield sites. So as a benchmark, I think it applies perfectly reasonably to greenfield developments. There's nothing further on this site from me.
Okay, thank you. Okay, I'm now just going to have a short adjournment. The time is now 11:08. So if we can resume now, please, and sorry, can we adjourn now, please, and can we resume at 11:35? Thank you. The time is now 11:35, so it's time for me to resume the inquiry. Just before we get back into the sites which are in dispute, during the adjournment, I received from the council the decision notice and the Section 106 agreement that was brought up in the first session this morning. Mr. Easton, I have asked Mr. Ford on to the appellants. It didn't appear from the email that was passed on to me that you had been CC'd in it, but I have asked for that to happen. So, are you in possession of those documents? Are you aware?
No. So what I was able to do, though, because I have the application reference, I was able to find the decision notice myself.
Okay.
What I don't have is the 106 obligation, and I don't know whether anybody in our team has been forwarded. No, I'm getting shakes of the head.
Okay.
It'd be very useful if documents are sent to you, sir, if we were CC'd into it.
Absolutely, yes. I mean, just in terms of 106, Mr. Easton, the documents itself, and there's also separately like an index document as well. So it kind of comprises two documents. But I say I've asked my case officer to forward those on to you. So hopefully they should be received during the session we're about to undertake.
Can I apologise for that? I think those my end that were obviously keen had heard what you'd said, sir, and we're keen to put that on the website. So they should be uploaded as soon as possible, but certainly I'll ask them as well, of course, to provide it in short order to the appellants. Okay,
thank you. Well, perhaps when we resume for this afternoon session, we can just confirm that has happened.
Thank you, sir. And it may be in relation to because I've certainly had a quick look through the conditions, and it may be before the end of this particular session, if you don't mind. Can I think Mr. Dodd should have a copy of the outline permission.
Yeah, I understood Mr. Dodd had already seen the permission, Mr. Easton, from what was said in the first session.
Yeah, but it's whether he actually has it in front of him.
Okay.
At the moment.
In front of me now.
Excellent. So do you mind, sir, if we at a convenient moment within this session, we perhaps just come back?
Or should we do that now before we get onto the next slide?
Fine. So I'm hoping that everybody does have a copy of the outline consent. And have you got it in front of you now, Mr. Dodd?
Yeah, almost.
Okay, that's a cryptic answer. Just let me know when you've got it on the screen in front of you.
Will do.
Okay. I think there's a point in relation to surveys that may need to be carried out in relation to under the conditions attached to the outline planning permission. I think the first, if you scroll through, first survey, condition 11, page 5 of 25, tree surveys, and then condition 12, ecology survey updates. You mentioned that the possibility of necessity of doing further ecological survey work. Condition 14. Well, 14 and 15 are archaeological conditions, one relating to site evaluation, 15 relating to field work. And then in the time available, the only other condition, and you might have picked up some more, Mr. Dodd, but condition 24 is a requirement. There's a series of contamination conditions, the fifth one of which relates to a requirement to carry out an asbestos survey prior to the demolition of any buildings. What? 2 points. First of all, had you picked up any other conditions that might affect the timetable? And secondly, what's your overall point about the need for surveys and the extent to which they could impact upon delivery?
I think so. There are other pre-commencement conditions, including 26, which is a Skylark mitigation strategy. But in relation to my point on lead-in times and the burden of pre-commencement conditions, it's, for example, with ecology surveys, it just goes to show the complexities in a site of this scale, and all of these conditions and the surveys being undertaken take time and money, and they, for example, an ecology survey set might take a whole season of ecology surveys to undertake, and that information is all being undertaken. It might be being undertaken concurrently to reserve matters preparation, as the council said, but it just feeds into my my assertion that there is quite a high burden of information that it takes to bring this site forward for development, especially on a site of this scale, where you're having ecology surveys across a very large area, or a tree survey or other.
Thank you.
You're on mute, sir. Sorry.
Apologies. Mr. Evans, I've obviously heard what you've said already about this earlier this morning. Obviously, I have now got the conditions, so obviously I can review them for myself as well. But is there anything further that you'd wish to draw to my attention in relation to what Mr. Dodd has just said?
Thank you, sir. Yeah, just going through them myself, I think they're fairly standard conditions that you'd expect to see for a site of this size. I don't see anything sort of abnormal there or something that's going to cause significant delay. Obviously, a number of these surveys can be running concurrently at the same time. And again, the test being reasonable prospect, I think sort of going through and looking at fairly standard conditions and suggesting that's going to significantly delay the site. In my view, it won't. These are fairly, the developers, L&Q will be aware of them. Indeed, sort of through their previous Gallagher homes will have indeed had some input into the conditions, or at least sort of signed them off or been aware of them. So in terms of what they think they can deliver, that they will definitely have taken them into account. Thank you. And obviously you can see them for yourself, sir. Thank you.
Okay, Mr. Dodd, do you have any final comments on this matter before I move on?
So just to say, we don't know who will be undertaking these surveys. We don't know whether it will be L&Q. Obviously, they've submitted details to charge a phasing plan. That might be a commercial consideration in relation to how they sell the site. We don't know whose responsibility these are, and it might be that these are submitted and prepared and undertaken only following the sale of the site. Fundamentally, that's not in the evidence, though, so it's an uncertainty.
Okay, thank you. Okay, I'm now going to move on to land west of Bardfield Road.
Sorry to jump in at this stage, sir. Just so everybody knows, we've received via the case officer both the decision notice, which we already had, and also a document that says index section 106 obligation, which I don't think is, well, it clearly isn't the entire document. It's either a heads of terms or it's a summary of the obligations. I haven't had a chance to look through it, sir. Would you, if necessary, would you permit us to come back and make any comments on that 106 summary if we felt we had any? We'll let you know either way.
Okay, I will do, Mr. Obviously, if that is the case, I'll have to consider also giving the council an opportunity to respond, yeah, which might be raised as well. So, okay, thank you.
Of course.
It's Mr. Evans. I note from the Scott's schedules that a reserve matters application has now been submitted for the land west of Bardfield Road site. What progress is there with that application?
Thank you, sir. So again, the reserve matter application has been validated, an officer assigned. There's a planning performance agreement in place that sets out the application will be determined in either the late January or February planning committee early next year. So that's the update I can provide. Thank you.
Okay. Mr. Dodd, do you have any comments on that?
Yes, sir. I mean, the proof of Mr. Evans doesn't refer to the reserve matters application. It said it was going to be submitted. When I saw the reference in the Scott schedule, the latest version of it that I've seen, I couldn't see the reserve matters application on the council's website. So I haven't been able to review that reserve matters application. It may be, obviously that's a significant update in terms of the site, in terms of its relationship to the definition of deliverability. So could I reserve my position on that before I have time to review the reserve matters application, which I think must be available now?
Obviously, Mr. Dodd, the housing and supply session is going to obviously essentially will be completed obviously today. So that I mean, obviously that raises some difficulty in terms of when you would do that. So what are you proposing?
Essentially, if there is a reserve matters application on the site from Hills Homes, which I think is a suggestion, then I will be revising my position on it to be in accordance and consistent with the other parts of my evidence. And looking at the council's proposed trajectory, I would say that if the reserve matters application is there validated, then I could agree to the council's proposed trajectory.
Okay, Mr. Evans, obviously Mr. Dodd has said that the application not on the council's website. Is that correct? And if so, is there any particular reason for that?
I'll have to check that, sir. I'll ask a colleague, or if I've time in between questions, I can certainly look into that.
Okay.
It might be that when it's very recently submitted, it doesn't appear quickly fully.
It might take some time to go onto the council's website. Yeah.
Okay. Well, Mr. Dodd, if that's the case, the only way I can see a way of proceeding on that basis is to do that through written submissions. Because as I say, the housing and supply session obviously will finish today. So that will be the only way to effectively deal with that. Mr. Williams, you've got your hand raised.
Thanks, sir. A minor point, but obviously the Scott schedule has been in the appellant's hands for at least over a week now, so it's unclear why this wasn't requested before. But if the position is only that it's going to get the parties close together, then I have no objection to that being confirmed after this session, so long as new points aren't taken after this session and it only comes to narrow the issues. Then I don't think there's an issue with you receiving that confirmation after this session.
Okay, well, thank you. I'll bear that in mind, and I'll come back to that at the start of the next session in terms of also what timescale I may put on that as well. Okay, Mr. Darmin, so are you in a position to provide any further comments on this site in relation to trajectories, or do you feel you need to be able to review the application on the council's website first?
I'd like to review the application on the council's website if I can, because I don't know the nature of the application and its contents. So I'd like to do that before setting out my position, please, and happy to submit sort of short written submission following.
Okay, thank you. I think on that basis, then I'm going to move on to the next site, which is land south of Maltings Lane, Gershwin Park, land northeast of Reed Road. Mr. Evans, in your proof on page 10, and in relation to the performer which has been received, I'm just trying to ascertain whether that is different from the outline scheme, or whether that relates to a reserve matters application that's proposed. Well, what is the most up-to-date position in relation to that?
Thank you, sir. Yes, it's a little bit of a complicated site. The part in the council's trajectory that we're looking at, the 24 units, it's sort of what's been left over from the outline of a much larger site that's now largely been completed. And this is sort of a little parcel that's remaining, that's got some remaining capacity on. I'm expecting it to be sort of application to be submitted, a reserve matters application or full application to be submitted shortly. And to be developed in the 5 years. So in that sort of context, it's a little parcel that's left over from an outline, a large scale outline that's now largely built.
Okay, Mr. Dodd, do you have any comments on that, please?
So that's not my understanding of the council's case on the site. I think Mr. Evans' appendix 4 in his proof, there's a public consultation document that's been provided in relation to a C2 scheme for the site, which covers the area in question.
Okay, Mr. Evans, do you want to provide clarification on that?
Yes, so Mr. Dodd's right in terms of pointing towards the consultation on it, but it's a 70-bed care home, and you can see from the bullet points 44 residential units and 3 neighbourhood retail units. So the 24 units in the council's trajectory is in relation to those, what it says is 44 units there. Obviously, they're anticipating a higher capacity, and the council is taking a cautious approach in regard to sort of just including 24.
Okay, before I go back to Mr. Dodd, Mr. Evans, do you want to provide any further comments on the trajectory for this site in terms of the the timing of the provision of the 24 units?
Thank you, sir. So we've included the 24 units in the 24-25 monitoring year, so a year before the 5-year supply trajectory finishes. I believe that's realistic given the site at the moment is largely just an empty parcel. The access is largely complete. There's already a road going from a roundabout to it, so the access is in place. So I believe the principle of development has been established through the outline, sustainable site. So I believe that an application, whether it be reserve matters or more likely full, given the different elements, will come forward, and the site's able to be just the modest 24, it's likely to be higher, will come forward in the 5 years. And you see that the council's trajectory allows a year's worth of slippage and for it still to be included in the 5 years. Thank you.
Okay. And Mr. Dodd, I'm also interested in your views in terms of the trajectory which you've put on for the delivery of this site.
So I don't think there's going to be any completion. Well, there's no sufficient evidence to demonstrate there'll be any completions from this site in the 5-year period. I disagree with the council that the principle of development is agreed on the site. It's clear that it's in the hands of another developer, and they are pursuing an alternative scheme for the site, which is very different to what the very historic outline consent allows for. So in a few ways, the public consultation suggests a care home, which is C2 and a different use class to C3. So there's not an outline planning permission for C2 on the site. It's 44 residential units as opposed to previous number that was allowed in the outline. And I also note in the consultation document that there's proposed to be some commercial space as well. There's not a planning permission for any of these uses, and it's not clear whether the council would accept those proposals in this location. They might have done a public consultation, there may be pre-app discussions going on, but fundamentally we don't know the form of that application. It could be an outline, it could be in full. We don't know when it will be submitted, and we don't know the final quantum of what that application will include. I think there's a significant amount of uncertainty that any development will be acceptable on the site, and I don't know whether the site's suitable for the proposed development. So on that basis, I don't think we can rely on any homes coming forward in the 5-year period. The council, by suggesting that this development is deliverable as predetermining the outcome of the development management team, who may have a different view on whether C2 is acceptable in this use or not, in this location or not.
Just Mr. Dodd, if you're approved to hand on this site, just at 7.29, which is on page 27, if you're there, towards the bottom of that page, it says the outline planning permission on this site has now been implemented. Can you explain what you mean by that, please?
So the outline planning permission was granted in 2012.
Okay.
It was a much larger site, and I believe hundreds of homes have been built out in the surrounding parcels by another developer. So not the party who have submitted the most recent public consultation. So it's a residual piece of land on a larger site, I believe, which has now been acquired by someone else who look like they are bringing forward an alternative form of development.
Thank you. Thank you for that clarification. Council, is there anything further on this site that it wished to bring my attention to?
Thank you, sir. Just to confirm, the 24 units in the council's supply for this site, that relates to the C3 element of the proposed. Obviously, you've got the consultation documents. That would be the C3 element that doesn't relate to any C2. The consultation document also says they'll be submitting a planning application by the end of this year. So there's some time frame there in terms of when the application will be submitted, and that's also in line with the pro forma which we've received from one of the from an agent on behalf of one of the developers. We anticipate that the C3 element will be completed by the Chelmer Housing Partnership, who, as you can see, are involved in the consultation. So there's a developer on board for this site for the C3 units. Thank you.
Okay. And finally, Mr. Dodd, anything further on this site you wish to draw my attention to?
It's clear that the C3 units are coming forward as part of the C2 development. So it doesn't look like they'll be coming forward independently, and that's clearly not the plan for the public consultation document that's been submitted. I don't think there's clear evidence that this site can be delivered in the 5-year period, and that's why I've removed all delivery.
Okay, thank you. Okay, I'm now going to move on to land off Church Street, north of Grove Field, High Garrett. Mr. Evans, just turning to page 11 of your proof.
Yes, sir. You
say a reserve matters application is expected imminently. Can you please give an update in relation to that?
Thank you, sir. So there's a pre-commencement condition for a site-wide design plan before the reserve matters is submitted. That was pending consideration until recently, but has now been refused. There are a few issues with it. So anticipating that the developer will go away, take on board the council's comments, or work with them through that, and they'll have another one to submit in a few months. And then that being approved, then they'll be pretty much ready to submit straight away in terms of the reserve matters. So unfortunately, there has been some slippage in regard to the submission of the reserve matters. But as I'm not sure if it's appropriate time to say, looking at the council's trajectory and the developers, Red Row, who have submitted an initial notice, and their pro forma we've received off them is much more ambitious. So I say the council have allowed time for the slippage to take place within its trajectory, and in my mind it's still realistic given the slight delay. Thank you.
Okay, thank you. Just turning to Mr. Dodd, just turn to your evidence on this site. On page 25, that's 7.18. Again, this is just maybe a matter of clarification, I don't know, but you refer to the time taken to take the site to market. And I just wondered, obviously, in relation to the involvement of Redrow in the site, which obviously you referred to in the paragraph before that as well, and also the Scott schedule details of house builder involvement by Redrow as well. I just wonder if you can kind of explain what you mean by that in terms of taking the time taken to take the site to market.
So following the grant of consent to Gladman in August 2020, it would have taken Gladman time to market the site and confirm the legal terms of a deal to sell the site. It appears as though Redrow will be the developer, but that process, so following the grant of outline, I submit, takes time. In comparison to, say, an outline that's granted on behalf of a house builder who will then be developing it themselves, there's no need to then market and sell the site. So in relation to the lead-in times, my suggestion is that it would have been a component of the total lead-in time to first completions on the site, as it appears that they've already made progress with it, and presumably throughout late 2020 and into 2021. But that is one factor that should be considered in the overall lead-in times to first completions. The fact that that's taken time to complete over the previous year.
Okay, and in terms of the trajectory you put forward for this site, and obviously hearing also what the council has just said in terms of the updates, I think it'd be useful for you to talk me through, your trajectory for this site.
So to be honest, I think my approach in this site is quite generous. It's quite a benevolent approach to take to the site, considering its planning status. I wasn't aware that the design guide condition has been refused, which to me demonstrates a clear potential issue with the site and bringing forward reserved matters applications. That will no doubt delay any potential reserved matters application. I think it doesn't mean that it's not deliverable in the 5-year period. Clearly, Redrow will work to adjust their plans and their design for the site to bring forward an acceptable development. But I think it will cause an additional delay. And on that basis, I would push back development another year from my proposed trajectory at paragraph 7.20 of my proof.
Okay, so you'll need to, if you obviously make an alteration to your evidence, Mr. Dodd, you'll need to run me through that in terms of that table then.
So on my trajectory, I will now only take into account 50 units in 2025-26, which is a total delivery of 50 homes in the 5-year period and a reduction of 100 homes.
Okay. Does the council any further points on this site that it would want me to consider?
So yeah, just to re-emphasise the point that the council has allowed for some slippage. We're taking a conservative estimate, and we weren't anticipating that everything would go exactly smoothly, and made that trajectory accordingly. We did anticipate some delays and taking a conservative approach. And I think that's demonstrated by the pro forma for this site, which is an appendix 1 of appendix 1 of my original proof. As you can see, Redrow there were anticipating a much higher level of delivery in the 5-year period. So again, I think that emphasises that yes, there has been and a few months in the context of a 5-year supply to the end of March 2026. I don't think justifies pushing the site back, given the context of the council's cautious trajectory. I have just been notified of a factual error that I made in regards to a previous site. If you want me just to clarify that now.
Okay, yes, if you can. Well, let's finish this site first,
okay, sure,
and then I'll move on to the next site.
Thank you.
I mean, yeah, Mr. Dodd, I'm asking again if you get any final comments on this site that you want me to consider.
Yes, sir. So the council's admission of not everything going smoothly is exactly the sort of factor that I've considered in my assessment of lead-in times for some of these sites, because things do not always just go to plan. I think basically they're going to have to resubmit the pre-commencement condition, wait for that to be considered with scrutiny before any reserved matters application can be submitted. So that immediately causes a delay. And on that basis, I think my revised trajectory is reasonable, given the status of the site at the moment. Yeah, I have nothing to add.
Okay, thank you. Well, that completes my questions on this side. So, okay, Mr. Evans, do you want to correct point
Thank
that
you,
you
sir.
made? Yeah.
Yeah, it was just in relation to the Long Green Crossing site. I believe I said that a PPA was in place. It's actually being sort of drafted and negotiated at the moment with the parties potentially entering onto one. And I think both the parties are keen to see it happen, but it's not in place yet. I think so. Just to correct that. Thank you.
Okay.
So, for what it's worth, my note for Long Green Road of Mr. Evans has said it was validated case officer determined by next year, PPA being finalised. But if it was a misleading impression that had been finalised, then that's corrected now.
Okay. Well, thank you for the clarification. Okay, now going to move on to land west of Panfield Lane. And again, on my first question for this is again, it's for the council. Just turning to page 12 of your proof, Mr. Evans. I note that the council does not include all the 189 units in the forecast supply, but then looking at the text, it appears to draw comparisons with the site in Witham. And I just wondered if you could kind of explain that approach, please.
So I'm just finding the bit in my.
Yeah, it's just down towards the bottom. If you go to page 12, it's essentially the last paragraph.
Yeah, thank you, sir. So this is a site within the district that's well advanced. It's not one of the sites being disputed today. It's in one of the large towns of Witham in the district, and that site is I think it's slightly smaller than Panfield Lane. However, I think it's not so much. It's not a useful comparison, and it was just making the point that site started producing 9 months from when they started work on site and got their detailed planning permission. So it's just emphasising that sites within the district, and it comes back to that point around phasing, that the reserve matters for the first phase can come forward quite quickly. It's usually for an accessible part of the site linking into existing infrastructure, and quite often it's been designed that way so they can start quickly, get on site, start producing completions, while other parts of the site that are more complex are developed, so there's not a delay in the continuity of the sites, and it doesn't affect on build out rate. So it's just making the point that in other sites of the district, large sites have delivered quickly from when they get planning permission. Thank you.
Okay, I'm going to come on to obviously the infrastructure of this site particularly in a moment, but Mr. Dodd, do you have anything which drawn my attention in terms of making this comparison with this site, the Lodge Farm Witham site?
I think the 9 months, that, as far as I understand it, that's from start of completions from commencing work on the site. As I understand, no work's been commenced on this site. Indeed, there are 4 major sort of discharge conditions applications that are required prior to commencement. So we would know about it if it had been commenced. And I would just refer to the previous delays on this site, which I think we'll come on to. But in terms of the 9 months figure and how that relates to my lead-in times, the evidence is obviously that it takes more than a year from detailed permission to first completions, based on previous track record in the district. So this figure is slightly different in that it's saying from commencement to completions, whereas my figure is from detailed permission to completions. So obviously there's another stage of work in between detailed permission and commencing work on the site.
Okay, thank you. Mr. Easton, you've raised your hand.
I have, sir. Thank you very much. So it's just, I was going to invite Mr. Dodd to comment on the utility of adopting the lead-in times for another site in a different part of the district in reaching a judgment about the lead-in times and how many units are likely to be delivered on land west of Panfield Lane, bearing in mind, of course, the council's view that national lead-in times are relevant, but they prefer an approach where they look at individual sites and reach an individual judgment about deliverability.
I think, sir, it shows that benchmarks are reasonable, but they should be one of the factors included in considering how long a site will take to deliver. But it's very important to, alongside those benchmarks, i.e. whether it's a site in Witham or it's my lead-in times assessment, due consideration must be given to infrastructure, planning status, etc., which demonstrate any progress or lack of on the site.
Mr. Evans, you have your hand raised. Do you wish to come back on what Mr. Dodd has said?
Yes, so it's just a factual point in regard to what the 9 months is for Lodge Farm Witham. I agree, each site should be looked at on its own merits. It was just a comparison to another large site in the same district. But in terms of the 9 months, that is actually from when the site Phase 1A gained detailed planning permission to when they started producing completions. So they gained detailed permission in September 2017. They started work on site on the same month, September 2017, and they produced completions in June 2018. So a period of 9 months. I'm actually from permission, probably should have used clearer wording in my proof. So apologies for that, but just to clarify that point. Thank you.
And just staying with Mr. Evans, moving on to the top of the next page, the top of page 13. Obviously, it refers to the provision of a new road and a roundabout. Can you give me an update, please, in relation to their provision, both in terms of funding and implementation?
Thank you, sir. Yeah, so in terms of the infrastructure for this site in regards to the highway network, the permission does require a link road be in place from Springwood Drive to Panfield Lane before the occupation of more than 50 dwellings. The latest correspondence, in my understanding, with the developer is that link roads and the whole of the first and Phase 1 are due to take place early next year. And just for context, in terms of Phase 1 can be accessed, that site can come forward without the access, so they can start work on the site, plot commencements, and indeed have 50 completions in place before the link road is complete. So actually to start work on site isn't required on that link road. In terms of the roundabout, I think that there is a bit of confusion with the appellants, having read their proof, which I'm happy to clarify now. In terms of the roundabout coming up Podsbrook, Rain Road, going east-west and then going into Springwood Drive. In terms of the requirement for works, and the appellant talks about a funding gap for that, the work for that scheme for that roundabout. But I can see where the confusion has taken place. It's the same roundabout, but a different scheme that's required by the planning permission. So the planning permission requires a much smaller scheme take place. I think it's the left-hand turn off Podsbrook going left onto Rain Road, and that's not the major scheme that Mr. Dodd was talking about in his proof. You also note that the condition in the section 106 that I think also included in Mr. Dodd's proof talks about part 2 in relation to that works. And what that is, it enables instead of actually providing that works, that roundabout, the developer can simply make a contribution to the bigger scheme on that roundabout. I think it's £560,000 contribution to that scheme. So they, instead of carrying out those works themselves.
Okay.
So yeah.
Okay, I'm going to come to Mr. Dodd in a minute, but just a clarification. So in terms of the roundabouts, does that have any limitation in terms of the number of the provision of the roundabout? Does that have any limitation in terms of the number of dwellings which can be provided on this site?
Yes, they can start work on the site and have plots under construction, but they can't have any occupations, my understanding, until that either that work has been completed, the minor work on that roundabout, or the financial contribution's been made. And my understanding is it's more likely to be the financial contribution route that goes ahead rather than them completing the works. Okay.
And when, on that basis, when is the roundabout due to be actually implemented then?
In terms of the wider scheme, the larger scheme?
Well, to enable development on this site to take place in relation to what you've just told me in relation to the roundabout.
So this roundabout is a little way away from the scheme. It's not connected to it. It's further down Springwood Drive, so it's just sort of off-site highway works improvements. So the scheme isn't reliant on it, but there was a Section 106 agreement to provide either A, some minor works to it for improvements, or B, the financial contribution to it. But my understanding is more likely to be the financial contribution, and the works of the wider scheme don't have to have started or taken place before they start dwellings. They can just make the payment, and then that's that issue dealt with. They can carry on work on the site and have occupations.
And is there a limit in terms of those number of occupations before the roundabout is complete?
No, they just simply, in terms of the bigger scheme, they just have to make the payment. In terms of if they were, which I think is unlikely, to actually complete the minor works themselves, they can't have anything complete until those works have taken place. But like I said, I think they're going to go down the financial contribution route.
Okay, well, thank you for those clarifications. Obviously, Mr. Dodd, in your brief on page 29 to 30, again, I've read your comments about the new road, the roundabout, and the lead-in times. But I think it would be useful for you to explain to me how that relates to the number of units that you've forecast to be delivered in the 5-year period.
Yes, sir. I mean, first of all, just a point of clarification. Mr. Evans referred to discussions with a developer. Does that relate to the pro forma that's been provided from the developer, or are there other discussions that we're not party to?
Mr. Evans?
Well, there's discussions sort of taking place all the time, as you might imagine, on the scheme. I think, in regard to the pro forma, I think it's not different to the pro forma. It's just more clarity around anticipating work on the link road to start early next year. But that's in line with the pro forma in terms of the housing trajectory.
Okay, Mr. Dodd, if you can answer my question, please. Thank you.
Yeah, of course. So I think what the council's saying is that the developer has opted for the financial contribution route to the wider scheme of works for the Springfield Drive junction. Is that correct? So that is from the Braintree infrastructure package, isn't it? I think is what the council is saying, which is where the funding gap is.
So the funding gaps for the wider work, yeah, on the roundabout, it's a much larger scheme, but sort of lots of developments are contributing to it, and the scheme isn't reliant on that works taking place.
But aren't those the works that cap the site at 50 homes?
No, that's the link road that caps it at 50.
I believe my reading of the Section 106 is that it's both.
Probably still have to have a look.
So do we have the Section 106? Because this is a potentially important point.
I'm not, as far as I'm aware. So again, Mr. Evans, if you can get one of your colleagues to submit that as an inquiry document, and then say, please make sure the appellant's CC'd into it as well.
Sir, maybe I could continue with generally my position on the site. which is that it's a classic example of where we can't rely on developer pro formas to give us clear evidence that homes will be delivered in the 5-year period. As I've put in my evidence, initially in 2019, the developer expected works to start and completions to be seen. Now, essentially 3 years down the line, we're still in a position where they haven't started work on site, haven't started pre-commencement conditions. And now we're saying works are going to start in February 2023, I believe, on completions. This site it's significantly delayed. It has known viability issues, which I've referenced from the committee report. Viability assessments were submitted as part of the application, and it was identified that a key issue was the burden of infrastructure related to the first phase. In my appendix JD4, I've provided the plan for the link road and the plan for the approved first phase. As you'll see from that, there is a significant amount of development that comes off the link road and is reliant on the link road. The first phase, it does require the implementation of part of the link road, I understand, which takes access from Panfield Lane. And I understand the council say that the rest of the plots will be substantially complete before they will be well advanced before the link road is completed. But fundamentally, there's a serious commercial consideration as to whether the whole of the initial link road can be funded and delivered before 50 homes. And I think there's some uncertainty as to whether additional development partners will be required, whether additional reserve matters applications will be required, given the link road provides funding to access to multiple parcels, which is shown in my appendix. So it's on that basis that I consider that there's some uncertainty as to when this will come forward, which is shown in the track record of pro formas on this site, with the same author of those pro formas having got it pretty wrong. Their best guess back in 2019 has turned out to be quite far from how quickly it has been delivered. We've got no evidence that the link road will be commenced quickly, as no pre-commencement conditions have been discharged or submitted. And then I'd say it's only on top of that they're going to have this uncertainty around whether it's reliant on the Braintree ITP, which includes the Springfield Drive junction and roundabout improvements. Those roundabout improvements are very significant from what I've seen. I think they require planning permission in themselves, and there's no planning application on that roundabout. And as I understand what we've just heard from the council, the developer is planning to contribute, make financial contributions to that scheme, which means that we are reliant on when that's going to be delivered, which is completely uncertain.
Mr. Evans, do you have any comments you want to raise in response to that?
Yes, I can clarify the roundabout point. Sorry, Mr. Dodd is right. They can have, I think I was thinking of Broad Road earlier in terms of the roundabout. They had to have, they couldn't have completions on. They can actually have 50 completions by the time they make the payment as well, or the minor works are completed. That's correct. So that's before I said 0, where it's actually 50. So that's sort of 50 in sort of favour. Yeah, so they can make the payment, and they can't have more than 50 completed before they make that payment. And just emphasise that the major work on that roundabout doesn't have to take place before the scheme can have more occupations. It's simply they just have to make the payment. In relation to the link roads, so the first point I was going to make is that it's a link road. It's a big bit of kit, but it's not disproportionate from what you'd expect that type of site to deliver. It's not a bit of motorway, for example. It's not wholly disproportionate as you would expect this type of site to deliver that kind of road infrastructure. So it's not disproportionate would be my first point. Essex County Council have done what the little bit is only a small section of work that they needed to do on their land to now enable the developer to have complete control over the timing of the link road and completion of the link road, which they're anticipating to start early next year, to obviously be complete, to allow them to then go on and produce 50 completions. And then probably a wider point I should have sort of pointed out at the start is this is a site with detailed planning permission through the hybrid application. So again, we're looking at, we're not looking at a Limb B site where we have to have clear evidence that completions will take place. This is very much already a detailed consented scheme. Thank you, sir.
I'll give you final comments on this site, Mr. but also I think would appreciate your views in relation to how this site stands in relation to which limb of deliverable under the MPPF it lies into in terms of the A and B.
Yes, sir. It's I agree with the council. It has got a full permission in terms of the first phase, which came through the hybrid planning application, and therefore it's falling into category A. And it's for that reason that I do think there will be some completions from this site in the 5-year period. And that's where my evidence covers when those might realistically come forward. So that essentially, I think we understand that there's significant infrastructure contributions. I disagree with the council that the link road is not disproportionate. I think it is disproportionate. It's a lot of infrastructure in my experience for a phase of that size. And as I've said, it connects to other phases of that development, which have a commercial interest essentially in the link road coming forward. And I suspect that, behind the scenes, there are commercial discussions going on balancing those infrastructure costs between the respective phases. And that's what's caused a delay on this site, because there's clearly a funding issue, hence the viability discussions as part of the application initially.
Okay, Mr. Evans, you've got your hand raised. And Mr. Easton as well. Mr. Evans, you'll go first, please.
So yeah, just in relation to a couple of factual points, that the link road itself is fully permissioned under phase 1, so they don't need any further permissions to build it out. They can carry on and build it now, and again, we're anticipating that to start early next year. And it does link. We'll come on to Towerlands, I think, is the next site, and it does link into that site. But again, they are in control of providing this link road, and it is fully permissioned. Thank you, sir.
Okay, Mr. Easton, did you want to? You had your hand raised.
I did say yes. Thank you very much. Yeah. So I just wanted to check. I thought it was Mr. Dodd's understanding. This might be something we can clarify by seeing a copy of the Section 106 obligation. But it seemed to me that Mr. Dodd's understanding in relation to the, I'm going to call it the big roundabout scheme, was that no more than 50 dwellings could be occupied until, firstly, the contribution from the scheme was made to the big roundabout proposals, and secondly, that those roundabout proposals had been completed. Now that makes sense. Now I know Mr. Evans takes a different view, and I'm not sure we can necessarily resolve this now. I think the way we resolve it is by seeing a copy of the Section 106 obligation. Have I correctly summarised your understanding, Mr. Dodd?
Yes, you have. Yeah, I think there's a cap on development, as I put in my evidence, in relation to both the link road and the roundabout improvements, which and that makes sense given the way the link road relates to that roundabout and comes onto the highways network. But just to be clear, sir, my case is not reliant only on that large roundabout coming forward. I think that's part of the issue, but I think there are others on this site, and that's reflected in my evidence.
And what others would you like to draw to my attention, Mr. Dodd?
The link road and the delays and the viability issues.
Okay, thank you.
So, sir, can I request that whoever's listening, I know that Mr. Evans is engaged in this session at the moment, so I'm not expecting him to be able to produce a copy of the Section 106 obligation, but can I invite the council to produce that copy as soon as possible? It looks like there may be a number of residual matters that we need to address in writing, which clearly we can discuss
Yeah,
the
absolutely.
timetable for that at the end.
So can that be arranged fairly promptly, Mr. Evans, in terms of the submission of the 106 agreement?
It's being done now. Sure.
Great,
I can say now the relevant parts of the section 106 that it relates to, if that's helpful for your notes.
Well, if you can do, I will. I mean, I'll start the next session. I'll address how we'll deal with these various things which are coming in or have come in. So, yep.
Sure. So I understand I've got some benefit as I've got it in front of me, but it's part 1, Schedule 10, Part 1 highways. And section C, I think, which is the bit quoted by Mr. Dodd, it says subject to part 2 of the schedule improvements to the Rain Road / Springwood Drive roundabout as shown on drawing X appended to this agreement Annex G. But then subject to part 2, what part 2 is highway contribution. And paragraph 6, in the event that the County Council serves contribution notice and the contribution information, the owner hereby converts with the schedule and the County Council not to permit more than 50 dwellings unless the highway contribution has been paid to the County Council. So it's to do with the payment of the money, and then they can occupy more than 50. It doesn't require for the actual works to take place. Thank you.
Okay, Mr. Dodd, you got your hand raised. I'm going to obviously permit written submissions on the 106 when it comes in. So I don't know whether you say you had your hand raised. Was that why you had your hand raised? Or you're on mute at the moment. Yeah, you're on mute, Mr. Dodd.
Sorry, sir. Yeah, I'll wait to submit written submissions on it following review of the section 106.
Okay, thank you. So I'm now going to move on to the Towerlands Park site. And go firstly going to the council again first on pages 13 and 14 of your proof, Mr. Evans, which concerns this site. I think firstly, it'd be useful for you to explain to me so I can understand the relationship between this site and the last site we've just discussed, because there does appear to be some cost crossover, certainly in relation to the provision of the link road and the roundabout. So I think that would be a useful clarification.
Thank you, sir. Yeah. So again, as you mentioned, it links into the link road of the scheme to the south, Panfield Lane. So Towerlands is directly north of the Panfield Lane site, and the two will eventually be linked. So the link road is controlled by the Panfield Lane site in terms of the access off Springwood Drive and going on to Panfield Lane, but there is a condition on the Towerland site which we're looking at now that no more than 50 dwellings will be occupied until those 50 until that link road has taken place. And also coming off the link road, there is then a road going up into the Towerland site, but we might move on to phases in a minute. But the first phase, the reserve matters, isn't reliant on that link road to begin. That is accessed off a different road network, so they can begin work on site and indeed have 50 completions before that, before the link road is in place. Thank you.
Okay, Mr. Evans, and in terms of the roundabout we've just discussed, does that have any bearing in relation to this site?
I believe it's just making a contribution to that roundabout, sir.
And is it the same Section 106 agreement, or is it different?
So it's a separate 106 agreement to the Panfield Lane side, but obviously they're closely linked in relation into the link road.
I think in light of that, I think it'd be beneficial to submit that document as well, the 106 for this site.
Okay.
Okay, Mr. Dodd, do you have any comments to raise in terms of what's been said so far on this site?
No, sir. I think this site is. I mean, my evidence is clear. I mean, it's reliant. It's capped at 50 homes following the implementation of the infrastructure on the site we previously talked about. So you're right. It's closely connected to the progress of that development. Since the exchange of evidence, there has now been a reserve matters application on the site. which the council have put in. I agree that that's not subject to the link road itself, but it is capped at 50 homes until that link road is completed. It doesn't make significant change to my evidence because I previously suggested there was clear evidence that this site would deliver in the 5-year period, and I've included delivery from it because there was clear developer intention. I noticed there was an advertisement, consent, some discharge conditions applications have gone in, but it is completely subject to progression of the problematic infrastructure at the land west of Banfield Lane.
Okay, thank you. Mr. Evans, as Mr. Dodd stated there, I know now there has been a reserved matters application that's been submitted. So what progress is there with that application?
Thank you, sir. Yeah, so the application was submitted 26th of October 2021 from Dan Dara, who are a national house builder. The reserve matters is being taken through a PPA which is agreed, that's been finalised, and there's a target date of the 25th of January 2022 committee, planning committee, to determine that application.
Okay, thank you. Mr. Dodd, did you have any comments you want to raise on that?
Sorry, sir, it was just in relation to the pro forma that's been provided. It clearly states, so this is in Mr. Evans' evidence, it clearly states that it's reliant on the 50 homes. There's a 50 home cap in relation to the other infrastructure at the other side. And they've suggested, when asked whether there's any barriers to development, they acknowledge that as a constraint. And there's a reference to possibly needing to vary this obligation, which presumably the council would resist, given there's a reason for the obligation originally applied to the planning permission, obviously, which is going to be in the section 106, which we can review, which is being submitted. But that does sort of show a slight bit of concern from my angle in terms of the developer is already suggesting that a fundamental planning obligation of the outline is going to need to be amended to deliver it.
Thank you, Mr. Dodd. Mr. Evans, do you want to respond to that?
Yeah, please. So I think, Mr. Dodd, the part of section 3 of the pro forma, which Mr. Dodd's referring to, I mean, I read it in a completely different way to Mr. Dodd. I mean, first of all, when it asks are there any barriers, it says no, and then goes on to explain. Dandara looking to secure reserve matters for phase 1 by January 2022, which lines up with the PPA. It then does talk about the restriction within the section 106, which limits the occupation to 50 dwellings until the link road is put in place on the adjacent site. In the event that this is not put in place, it would be necessary to seek a variation. So from reading that, they're acknowledging the fact that there is this condition in place through the section 106, but they're not suggesting that they don't think it will happen. They're not suggesting that necessarily it will have to be so the permission will have to be varied, simply just acknowledging that it might take place. And again, I would ask for that to be read in conjunction with the trajectory received from Dandara in the pro forma, which is more ambitious than the one the council is using. And they show 100 completions to take place by the 2022-2023 monitoring year. So 100 completions by the end of March 2023. I mean, the council have used a more conservative estimate. So in relation to that 50 dwelling occupancy limit, Dandara obviously looking at that in the case of summer to autumn 2022, they're concerned that they might reach the 50, or not concerned actually, they're just making the point it'll be that sort of time frame, summer, autumn 2022, where they think they're going to reach the limit of 50 occupants, and the link road will have to be in place then, not that they're only going to be able to deliver 50 in the whole 5-year supply. So that's the context which their comments are made. And the council use a more conservative estimate in its trajectory, and believe that is that's obviously dependent on the link roads. But again, going sort of as it's linked with the link road at Panfield Lane, the developer or developers of that site were involved in the original outline, that have been involved in the drafting of the Section 106 agreement. They clearly know what the requirements are and have submitted a pro forma to us saying that they're going to be able to deliver that link road to have the completions in their trajectory. So I believe the evidence is in front of us to suggest that the link road will be put in place and the completions come forward on both sites in line with the council's and the developers, or the council's more conservative approach to the developers' trajectories. Thank you.
Okay. Mr. Doll, obviously I've heard both parties' views in terms of the interpretation of the pro forma, and obviously I'll take my own view on that. But Mr. Dodd, is any final point on this that you'd want me to raise? I do have another question on this side, but I notice you have your hand raised.
Yeah, it's just no matter what the developers say in the pro forma, they have no control over when that link road comes forward. And I just wanted to make that point. It's on a separate site and it's related to a different development.
Okay, thank you. Obviously, again, this is one of the sites which features in the Station Road appeal decision and also in the evidence that the council submitted at the end of last week related to that. So Mr. Dodd, again, I'd be keen to hear your views on that.
The inspector in the Station Road decision found that it wasn't a realistic prospect. That's not my evidence. I also think that the circumstances have changed since the inspector made that decision with the submission of a reserve matters application on the site. So I haven't made the same case as was made by the appellants in that appeal. But I suppose the inspector's caution, given what I've said, I do think is a sensible approach to take.
Okay, Mr. Evans, in relation to the Station Road appeal decision, is there anything we should draw my attention to that's not been raised, you've not raised already?
Thank you, sir. Yeah, so in my mind, that the Station Road inspector's main concern was the lack of reserve matters, and that's now clearly been addressed with a submission, and we've set out the timetable for the determination at the 25th of January 2022 Planning Committee. Thank you.
Okay. Staying with Mr. Evans, in relation to the update document you submitted at the end of last week, you mentioned a further site. That's on page 7 of the document.
Sorry, sir, too many documents.
That's okay.
I'll find it on the website instead.
So it's the so the statement you submitted at the end of last week in relation to the Station Road appeal decision. It's the main document.
Yeah.
And on page 7, you mentioned a site land north of Oakstead, Halstead, which obviously doesn't appear in terms of the sites which are in dispute between the main parties. And my question simply was, what bearing does that have on my decision?
So this was a site which was removed by the Station Road inspector following that session, and as made clear in the appeal decision. Obviously, it's not a site that's being challenged today by the appellant or in their evidence. So the purpose of including that site in the update note was just in response to the Station Road inspector, and just suggest that things have moved forward again since the inspector of the Station Road appeal heard evidence, and that's in relation to the submission of a full application for 80 dwellings from Bellway Homes house builder. So I'm not sure. So it's just if you, as the Station Road appeal is in front of you and both parties agree it's sort of a consideration, it's just to be clear on that site as well. Thank you.
Okay. And Mr. Dodd, is there anything you wish to draw my attention to in terms of land north of Oakstead, Halstead?
No, there's nothing, sir. I mean, I reviewed that full planning application when I prepared my evidence, and I thought it was a deliverable site, so I haven't contested its delivery.
Okay, I'm now going to move on to the windfall allowance item on the agenda. Okay, firstly, question for Mr. Evans. Obviously, in your evidence, I have read what you said about historic delivery rates and then the windfall allowance that's utilised. I'd be interested in knowing more, though, about how you get to the position of the windfall allowance itself that you've actually identified within the supply period.
So how we've come up with the total figure of 225?
Yes, essentially, yes, yeah.
Yeah, so so we've used that figure for some time now. My understanding is that, obviously we consider it appropriate to include a windfall allowance. When looking at what the figure will be, obviously we looked at a variety of options, what the evidence was at the time when we first included one, and that the sum of 225 was recommended to us by some consultants, Peter Brett Associate, in relation to when they were looking at our 5-year supply analysis for the council. And the council originally suggested a slightly higher figure, I think around 300, but we opted, given the advice of Peter Brett Associates, we opted to use their lower figure of 225 for the whole 5-year supply. And as you'll see in our evidence, so we suggest, given the previous rates, that's a very conservative and cautious amount, and the council consider it's likely to be exceeded by a fair amount. Thank you.
Okay. And Mr. Dodd, what's your views in relation to the council's windfall allowance?
So there's two sources of supply here, sir. There's the small sites, which are identified in Appendix 2 of the council's 5-year supply position statement, which are commitments or are under construction. And then there's the sort of the windfall allowance, like the general figure that's been included in years 3, 4, and 5. My view is that the small sites, a lot of them are windfall by their very nature, and that there's a realistic prospect that they will be delivered in 3 years before they're expired, because if they've got planning permission at the base date, that's the standard implementation condition applied by the council. And therefore, it's logical that those are the windfall sites for those first 3 years of the trajectory, and then an account is made. And I agree that it's perfectly appropriate. I don't disagree to include a windfall allowance totally. And I don't disagree with the council's 75 homes per annum figure. However, what I do contest is the delivery or the assumption that will deliver in the 3rd year of 5. When obviously there are already windfall sites being counted for that year from the small sites that are either under construction or have permission at the base date.
Mr. Evans, what's your view in relation to this issue of double counting, which has been raised?
So my view is that there logically can't be any double counting, and I'm happy to go on and explain why. So just going back to actually what the windfall is that as of the base date, obviously, as Mr. Dodd said, there are a number of small sites already in the council supply. They're accounted for, they're in the trajectory, they're included in the overall figures. However, we know from past experience that there'll be a number of sites that don't have permission and aren't included as of the base date that will gain permission subsequently in the 5 years and deliver a number of completions. So the evidence set out in the Council's Housing Land Supply Statements, core document 8.14, in particular tables sort of 5 to 7 sets out our windfall analysis. And what that shows is in the first year, from the base date, a very small number, as you might expect, barn conversions, maybe single dwellings do gain permission early on in that monitoring year and actually do produce completions in that monitoring year. It happened from the council's analysis, it's sort of 6 to 10 completions only. It's not a huge amount. But then, as you might expect, as you move on to year 2, then you've got 2 years worth of time for sites to gain permission and produce completions. And that's between about 50 and 60 completions for that year. And then that sort of trend continues. So by the time you get to year 3, it's between about 75 and 190, quite a lot of variation there. By year 4, it's well in excess of 100, actually sometimes over 200. And year 5, actually, well over 200 completions take place. And the supply, Mr. Dodd's talking about in his Appendix 3, where he looks at the small sites, the sites already identified in the council supply. So these are 2 completely separate sources of supply. So I'm not quite sure how you can have double counting in that regard. And somehow the inclusion of these small sites in the council supply somehow preventing other sites, the windfall sites, coming forward and producing completions in the 5 years. I don't see the logic there. The council have clear evidence that they do come forward, these other sites, and produce in excess of 225 completions, looking at the 5-year supply as a whole. And just sort of as a last point, in my mind, the important question is, what is the total windfall allowance for the council, the 225, and is that reasonable? And actually how you split that across the 5-year period, whether you apply equally across 5 years, whether you have it in 3 years as the council have done, or if you condense it into sort of 2 years at the end, it doesn't make a difference to the overall 5-year housing land supply completion. There's still 225 dwellings. So I think the important question is there evidence that 225 is reasonable? And if it is, I think that's the key question. Thank you, sir.
Okay, Mr. Williams, you've got your hand raised.
Thank you very much, sir. Can I just cover, as I understand it, and Mr. Evans will correct me if I'm wrong, and I apologise if I'm repeating, the evidence base that Mr. Evans referred to in relation to the windfall looks at those permissions that were granted after the base date of the 5-year supply that we're looking at only. So it has nothing to do with permissions that were granted prior to the base date and may fall into the small supply category. And what that evidence actually shows, as Mr. Evans clearly explained, is that there's empirical evidence that the windfall rates, when you're looking over the 5-year period of sites that granted permission within that 5 years and deliver within that 5 years, is significantly higher than the conservative estimate that the council have relied upon, which is 225. I hope that's a correct summary, Mr. Evans, of how I understand the position, and I hope that helps you, sir.
Okay, thank you. Mr. Dodd, do you have any further comments you'd want me to have regard to in relation to this issue of double counting?
Yes, I do. So in relation to the tables in CD 8.14 on windfall allowance, I accept that it includes sites that were not in the supply at the start of those 5-year periods. But then it covers a 5-year period where the 5-year supply statement would be rebased every year, as the council have done this year in 2021. So would then presumably include those small sites as either a commitment or under construction. So I accept that there are high figures that are shown there, but fundamentally, if you add the 225 homes relied on from windfall and then the small sites that are under construction in the council's trajectory, it's far in excess of the figures that are shown in those tables. So as an example, I've set out that in year 3, there's small sites relied on to deliver 250 homes, plus the windfall, that's at 475 homes already, and that doesn't include the small sites that are relied on in years 1 and 2, the trajectory. And it's on that basis that I don't think in the council's total supply now, I don't think it is significantly lower than what's set out in the council's windfall allowance. I think it does broadly relate to the evidence that has been seen in Braintree previously. And I suppose the point on double counting is the council have removed the windfall allowance from years 1 and 2. So there's some acknowledgement there that those sites are already accounted for in the supply. And my logic is only extending the council's submission, i.e. if you're going to remove sites from years 1 and 2 from the trajectory, then my logic is that it makes sense to remove from year 3 too, because that accounts for the realistic timing that those sites will be delivered.
Mr. Evans, do you have any comments on that?
Yes, sir, please. So in relation to Mr. Dodd's point around removing the 75 from the first 2 years, that's not the case. That's not how we didn't start a position of 75 a year and then removed 2 of the years. We simply considered 225 as appropriate and then considered what was the most appropriate way of displaying that in the trajectory, and we decided simply on having 75, that 225 split across as 75 in the last 3 years as just being an appropriate way to represent that. In regard to the double counting point, again, I'm slightly confused because the small sites which Mr. Dodd's identified are in the supply at the moment. They're contributing to the 5.27 years that the council say we have. In their own right, as lines on the spreadsheets, they're in there. What we're saying is that in excess of those, the council's evidence that other sites that we haven't identified at the moment, they're not in those spreadsheets, will gain permission and produce completions within the 5 years. So that they're two completely sort of separate sources of supply. And just, I understand that they do take a little bit of getting your head around these tables in regard to the council's evidence, but just to take table 5, for example, that is looking at the 5-year period from a 2013 base date. So the 1st of April 2013, it's looking to see what permissions, obviously that sets out what permissions there are. It's looking to see what in excess of the permissions we've identified actually come forward that we haven't identified and produce those completions. And those tables set out what those completions take place. So there's no issue with resetting the base date. Simply we're looking at a 2013 base date, and actually by 2018, when the 5-year supply period is over, what permissions have come forward that we hadn't identified at the base date and produced completions. And that showed that 487 completions had took place that we hadn't accounted for, and that's why we have the windfall allowance. And actually looking at a 2014 base date and a 2015 base date, those figures are actually higher in terms of the sites that come forward and the completions that take place. Thank you.
Thank you. Mr. any final comments on windfall before I move on?
Just as I put in my evidence, it isn't two different sources of supply. The small sites include windfall sites, and it's acknowledged in the council's own trajectory that on some sites it says post submission windfall, and the nature of those sites coming forward, i.e. as windfalls, not on allocated sites, that's the way they've come forward, and now they're included in the council's supply.
Mr. Evans, I've obviously heard quite a lot of views about this. I understand what the difference between the two parties is. So is a new point you want me to raise, or you're on mute, Mr. Evans?
Sorry, sir. It was just to explain the context in regards to that windfall annotation in the trajectory. I think we're just showing that it's not a local plan allocation, where in regard to the actual windfall allowance, what we're looking there is sites that are not identified at the base date. So we're kind of using it in two separate senses there, and they are two separate sources of supply. One are included in the supply at the base date, and one aren't, and ones that are going to come forward since. Thank you.
Okay, thank you. Okay, now I'm going to move on to item 6, appeal decisions and case law. Mr. Dodd, on pages 16 to 18, of your proof, you outline three appeal decisions, or decisions of the council. But they're all actually all appeal decisions. So my question is, anything particularly within those you wish to draw my attention to in terms of what's in your evidence?
Yes, sir. I suppose I've summarised the findings, I think, in terms of the interpretation of those decisions in my proof. But something I particularly draw your attention to is in relation to JD8, the Son in Common decision, where the inspector at paragraph 21 considers trajectories provided by landowners, agents, or developers that sites come forward, and it suggests that wider factors should be considered in terms of the delivery, and that they identify technical, legal, commercial, financial aspects of delivery should all be assessed alongside pro formas, and I completely agree with that approach, and I think that that's the approach that I've taken towards my assessment of the council's supply.
Okay, thank you, Mr. Dodd. Mr. Williams, do you have any comments on those appeal decisions?
Just on that last one, so this is set in the context of the submissions I made at the start as well, so I won't repeat myself there. With respect to Mr. Stevens, I know he's an experienced inspector and has handed down a number of appeal decisions in relation to 5-year supply matters that have caused some controversy. With respect, in my submission, Mr. Stevens does he says that, and this is the penultimate line, last paragraph 20. The advice indicates to me that expectation of clear evidence must be something cogent as opposed to merely simply assertions. Well, that's fair enough. There must be strong evidence that a given site will in reality deliver housing. Well, sir, that, with respect, is the wrong test to apply. There's no requirement for strong evidence, nor in reality that it will deliver housing. That's exactly what St Modwyn said isn't the approach to take. It is whether there is a realistic prospect. It's not about whether it will, it's whether at the time of making the assessment there is a prospect, and that prospect is realistic. So with respect to Mr. Stevens, it is an example in my respectful submission where the inspector hasn't had regard to the operative test. And of course, pro formas are not in all cases the answer, but as I said earlier, in my respectful submission, there's no hard and fast rule about the weight to be given to pro formas. It all depends on the quality of the pro forma, the realistic nature or otherwise of what they're projecting, and other factors such as whether the site is constrained or not. So with respect to Mr. Stevens, it's not appropriate if he's intending to do so to draw hard and fast rules about what is and what is not clear evidence as a matter of generality. So that's what I had to say about that particular case.
Okay, Mr. Easton, you've got your hand raised. Do you wish to comment on this? What's been said?
I do say yes, thank you very much. Mr. Dodd drew your particular attention, sir, to paragraph 21 of Mr. Stevens' decision, and that's, I think, not a matter between us, because in essence, what paragraph 21 is saying is that local planning authorities and decision makers, in this case you, sir, ought not to consider evidence from landowners, agents or developers entirely uncritically. And there are matters which one would take into account, such as the commercial legal aspects of a site being delivered, again, all of which, as I understood it, the council takes into account. And for there are a number of sites where, during the course of today's session, Mr. Evans has indicated that he thought that individual developers' estimations about trajectory and delivery were somewhat optimistic. So I don't think paragraph 21 takes it any is controversial between us and the local planning authority, but it just underlines what I think is a sensible point, that when you're considering evidence from people promoting land for development, one ought to see it in a critical way, rather than accept it completely at face value. And again, I don't think that's a matter between us.
Okay, thank you, Mr. Easton. Mr. Evans, you've got your hand raised. I have a question for the council next in relation to these matters, but so maybe I'll pose that question first, and if you know, if there's something else you wish to raise, you can do so afterwards on this matter. I notice the council, obviously, Mr. Williams already mentioned the Modwin decision, Modwin case law, but in relation to what the council submitted, I noted that a number have been put in relation to core documents that relate to housing land supply. So again, similarly, is there anything that you wish to draw my attention to that you've not done so already?
So can I just check before Mr. Evans answers that question? I'll ask him to do that. You should have received from Mr. Evans a short note explaining the relevant parts of that judgment.
I have, yes.
Sir.
Yeah.
Thank you.
Okay, that's fine. So, Mr. Evans, is there anything you wish to draw my attention with regard to that, or?
Thank you, sir. Yes. First of all, I've just been handed notes in the Sunningfield. Sunning Common decision is subject to a JR at the moment, I believe.
Okay.
Just for your note, in relation to so I'm happy you've received the council's note setting out the relevant appeal decisions, and obviously I don't think I've really got much further to add than what's on that note. I would just like to draw your attention to the appeal decision Rectory Farm Woburn Sands, dated the 27th of April 2020, core document 6.6, and just how that inspector treated the use of pro formas. Again, sort of as Mr. Williams was alluding to, there isn't a hard and fast rule. They have to be sort of looked at on an individual basis. I just made the point that the council haven't taken it at face value. We have sort of challenged them and checked those figures through, and as I explained right at the beginning, reduced the numbers on quite a few occasions to take a more cautious approach, and that to me seems like a sensible approach. Thank you.
Okay. Mr. Easton, I was asking whether you wish to comment on those the decisions which the council put into the core documents, and also the summary that Mr. Evans has provided as well. Do you wish to do that?
So only very briefly, but the first point I want to make is in relation to whether or not the Sonning Common decision has been challenged. Mr. Williams will agree with me on this basis that there is a presumption of legal regularity, so that unless and until a higher court declares that that decision is unlawful, we presume that it is lawful. We don't know on what basis it's been challenged, so I would caution you against taking into account the fact that this may have been challenged. So the second point I'd make is, to the extent that it is necessary to make comment on the appeal decisions and court judgments that have already been relied upon, I think the time for that is in closing submissions. But I would just add to that remark this point, that there is a danger, I'm afraid, in these sort of cases of becoming overly forensic and overly legalistic in one's approach to assessing the deliverability of sites. I think ultimately there is nothing between us and the local planning authority that is a judgment for you, sir, to consider whether there's a realistic prospect of sites delivering housing within the 5-year period, and if so, how many dwellings. It's a relatively simple judgment point, and an awful lot of time has been spent in other inquiries and in front of the courts in dissecting in a lot of detail what individual parts of the MPPF and PPG actually mean in practice, when I think ultimately it's quite a simple and straightforward exercise. So for that reason, I will mention something in closing submissions as to what I consider to be the correct approach, but I'm not going to spend ages and ages being overly legalistic about it, which I hope will be helpful.
Thank you, Mr. Easton. I'm now going to move on to item 7, which is the 5-year supply position. Obviously, I'm aware there's been, as these sessions have been taking place, there's been some changes in terms of the some of the numbers which have been put forward now. But I think first of all, I'll start with the council. council's most up-to-date position in terms of the evidence that I have in relation to its position is set out in the response to the Station Road Appeal decision document. And I'm looking at page 7 on that, Mr. Evans. And it sets out a position of 5.27 years. Is that still the council's position in relation to what has been heard?
Yes, thank you, sir. That's that remains to be the latest position. I haven't heard anything today or for myself personally and on behalf of the council to concede any units on any of the sites. So we maintain that 5.27 is our position. Thank you.
Now, Mr. Stoll, in relation to the appellants, obviously there have been some changes made as we've kind of gone along. So, I mean, the position as it stands in your evidence, I think you set out at 7.74. And that obviously stated at a shortfall of, well, a 4.52 year supply. So in terms of the changes which you put forward, what is now the appellant's most up-to-date position on that?
Sir, could I mean, there was one site where I was due to review a reserve matter application, which I'll be making submissions on. But essentially on all other sites, obviously I've conceded some homes on Long Green and Braintree Road during this session, which results in a change in my overall deliverable supply figure. But I've also amended my position on the land off Church Street too. So maybe I think overall, I think exactly it will end up similar to my position in my proof, which is around 4.6 years. But maybe we could provide an updated Scott schedule to you or an updated trajectory, which clearly sets out the position of both parties following this roundtable.
Okay.
For clarity.
Okay, and just staying with you, Mr. Dodd. Again, I appreciate obviously the figure will be different now, but it's more in terms of the what it differs and what bearing it has. Kind of over the page, on page 35, you set out a position of 4.8 years. So I think you kind of talk me through how that's different from the 4.52. Obviously, I appreciate these figures are obviously going to change, but I mean, it's more in terms of why there is the difference.
So that's essentially a scenario based on just removing sites where I considered there was no clear evidence that they were deliverable in the 5-year period. The figures have changed slightly on that, but essentially my main position is that all of the reductions I've set out should be taken into account in your decision. And that is the council's true 5-year supply position, which, as I say, is between 4.5 and 4.6, the exact position to be determined. But I presented the other scenario for your benefit in the sites where I don't believe there is clear evidence. The council's supply position would still stand below 5 years. So there's essentially two types of site. There's sites where I've contested the lead-in time to delivery, and therefore the amount of homes that are going to come forward in the 5-year period. But then there's also sites which I think should be removed entirely due to no clear evidence. So that scenario at para 7.77 of my proof is a scenario where the sites where there's no clear evidence have been removed only.
Okay, and of those two scenarios, which is your actual position that you want me to have regard to?
Para 7.74 is the position that I think you should have regard to, which is all of the reductions I've proposed in my evidence, and obviously it will be updated with a couple of sites where we've changed. Okay.
Now, in relation to that, in terms of the update of the position, and also the commenting on the 106 agreements that we've kind of touched on and discussed in part, I'm going to return to that at the start of the next session in terms of how I propose to deal with that. But my last question in terms of housing and land supply is, are there any further matters on it that you wish to draw to my attention to, Mr. Evans?
No, thank you, sir, and thank you for running the session today.
And Mr. Dodd?
So there is, from my perspective, that there's one key point, which is, I think, just with the reduction of Broad Road from the trajectory, the council's position would stand at only 16 homes. As I've put in my evidence, I think the council's position is fragile anyway to any slippage in delivery from any sites. And just with the removal of Broad Road, the surplus would be only 16 homes. And that would, for you, mean that you'd only have to agree with us on one other site that's been contested. And I suppose one question from me is essentially, is there sufficient certainty that all of these sites will deliver fully as the council say they will, with no slippage? And I think there's multiple scenarios in which you could find that the council do not have a 5-year housing land supply.
Okay. Well, thank you for your contributions to that session. As I say, I'll in terms of the procedure, how I'll deal with the 106s and so forth, I'll deal with that at the start of the next session. The time is now 1:15, so we'll adjourn and we'll resume at 2:15. Thank you.
Thank you, sir.
Good afternoon. The time is 2:15, so it's now time to resume this inquiry. First of all, I just want to run through the documents which have been submitted, just to make sure, obviously, we've all got those documents. So, firstly, the Broad Road outline decision notice. Mr. Easton, have you now received that document?
Yes, I think that was the one that I had already, but
okay.
My understanding is that I suspect we've got all the documents you're about to run through.
Okay, fine.
But if we don't have any of the ones you mentioned, I shall let you know. Okay,
fine. Well, the Broad Road decision notice, I shall call inquiry document 4. I also have the Broad Road Section 106 agreement and also an index. And I'll call that inquiry document 5. I also have the Panfield Lane Section 106 agreement and an index. I'll call that inquiry document 6. And I have the Towerlands Section 106 agreement and index, and I'll call that inquiry document 7. Okay. And considering obviously the submission of these documents, what I've decided to do is actually give both main parties the opportunity to make written submissions on them. And what my intention would be that they would be submitted by the time we open next Tuesday. My thinking is on that is if it's done by next Tuesday, I will see the advocates' views in a moment, but if it's done by next Tuesday, then that will also give the advocates opportunity, if they wish, to refer to them in their closing submissions as well on the Wednesday. So that was my thinking. So I noticed, Mr. Williams, you had your hand up fairly promptly there. So is there a matter you wish to raise?
Yes, of course. I in principle have no objection to further comments on these, subject to 2 points. So if I may, the first is that. Well, obviously you requested them, sir, and that's why I've no objection to both parties being permitted to comment on them. The first point is that they have all been available publicly on the council's website, and indeed the appellant had the opportunity, we know, in relation to the Panfield Lane Section 106 to review it because they commented on it in their brief. And I would be concerned, therefore, if what came forward materially changed the appellant's position in terms of any of the sites. Now, of course, if it's just drawing attention to points that have already been made in either the evidence or the Scotch schedule or orally today, and please see whatever provision, I have no objection to that. But if it went a lot further and materially changed their position or new submissions were being made, I would be concerned about that, sir, simply because there has been an opportunity to review these, and in fact we know the appellant has reviewed them, at least in part, has taken that opportunity. So I hope that position is clear. And the second point is, in light of that, I did wonder whether a sequential exchange was more appropriate. It may be that if Mr. Easton's team simply put a note in that that doesn't go any further than what has been said already, that we either don't need to respond or we'll have a very short response. But if there was something that was wholly new, obviously we would then need an opportunity to respond to it. I have to say, I don't think that would be appropriate to introduce something new at this stage, and I don't expect it to be. But I just wanted to raise those points.
No, I mean, certainly, Mr. Williams, on those points, I mean, we had quite a robust discussion this morning about the various scenarios in terms of what both parties thought in any case. So I wouldn't expect new evidence to be submitted. And if it was, obviously, I'm in my rights not to accept the evidence if it is new evidence in any case, or give the opposing party the opportunity to comment on it. So those two scenarios anyway. Now, so it's certainly not my intention that this is a way of introducing new evidence. It's simply the fact that these documents have been submitted, whilst have been referred to before during the course of the inquiry. And I feel, in terms of best informing my decision, that I should give both main parties the opportunity to comment on those.
And so, as I made clear, Scott, I have absolutely no objection to that approach. And if Mr. Easton's team isn't going to raise any new points, then we can put in our notes at the same time, because we can simply say this is the point that we made. Here is the relevant provision in the 106 or the like, and I have no objection to that. Okay, well, I mean, I say my intention is obviously, because the timescales are fairly short, Mr. Williams, is to set the same deadline for both parties. But as I say previously, I'd reserve the right not to accept new evidence in any case, or secondly, give the other party the opportunity to comment on it. And that's not something I want to do, because I don't really want to be in a situation where I'm seeking comments on those sort of documents after after I've heard closings and the inquiry is closed. But obviously, I would reserve that right. So I do feel that no party will be prejudiced if I took that approach. I understand that, sir, and I hear that. And in the first port of call, let's hope that we can all put short notes in on Tuesday, which are uncontroversial. Okay. And Mr. Easton, in terms of you, do you have any comments to raise on that?
No, sir, other than to echo, I think one of the points my friend made is that our collective role is to inform you as best we can, so that you can make a judgment based on all the most up-to-date information. I can't guarantee, albeit I think it is unlikely, that we're going to alter our position in light of the documents that have come in today. It's simply the need to clarify a number of points. I think that one obvious example is the terms of the Section 106 obligation in relation to land west of Panfield Lane. So, we can meet the Tuesday deadline. I suspect what we are going to say is going to be uncontroversial, and to the extent that any further response is necessary, I think it's unlikely. But clearly, it's within your remit, sir. If we add something that goes way beyond the scope of what you anticipated would come in, you can form a view and reach a judgment about whether it's allowed in or not. Like I said, I think it's unlikely.
Okay, thank you. And also, with the same deadline as well, I was going to set, was the appellant's views in relation to the site, Mr. Easton, land west of Bradfield Road, in relation to if you remember, the issue of the reserve matters came up this morning, and Mr. Dodd obviously, yeah. Sorry, carry on.
Yeah, so the only thing I'd say about that is I think the reason that Mr. Dodd reserved his position in relation to that site is that although he didn't doubt that a reserve matters application had come in, he hadn't seen it because it's not on the council's website. So the only potential wrinkle in that approach is whether or not the reserve matters application, the documents that support it, are actually available.
Okay,
I mean, only the council can answer that question.
Absolutely, but I also think as well, if that is an issue in relation, I don't know, in terms of how these things work, the alternative obviously would be for Mr. Dodd to contact the council in terms of the documents that he might want to view as well. If there's an issue in terms of seeing those documents on the website. However, I'm sure both main parties should be able to sort that out. I'd hope anyway. Between themselves.
So I can offer up Mr. Evans, I hope he doesn't mind. If Mr. Dodd wants to see anything particular outside of the inquiry, if he contacts Mr. Evans this week, then that, so long as within the gift of the council, will be provided.
Okay, thank you for that confirmation, Mr. Williams. And also as well, for the appellants as well, obviously the updated 5-year housing land supply position as well. So, simply in terms of that, really, obviously I've got the evidence. I'm just essentially the number I'm looking for. As I asked the council to confirm their position, which they did, and it's essentially the equivalent of that, Mr. Easton, which I would wish the appellant to confirm.
Yeah. So can I just be absolutely clear about this? Because one option, it may be overkill, is to produce an updated Scott schedule. The other option is to reproduce a table similar to the one that Mr. Dodd has produced at page 34 of his proof, which comes to an overall view about the total amount of dwellings he says is going to be deliverable. Was it the first or the second of those that you're anticipating?
Well, I was anticipating simply in terms of what's in Mr. Dodd's proof.
I'm sorry, you put it away now. Apologise.
I have indeed, yeah. In terms of the 5-year line position, simply, I mean, paragraph 7.74 on page 34, which is where he sets out the 4.5 2 years, and then over the page, his position at 7.77. You know, simply those figures be updated.
Yeah, except that the table above 7.77, as he explained, sir, it's a subset of the total number of reductions. So it's where you, in terms of lead-in times, if you disagree with us in relation to lead-in times, but accept our evidence that there's no clear evidence, then that's the table. But I think the key table, which includes all of the deductions, is the one just above 7.73, and then drawing it together at table 14 below 7.73.
Okay. Well,
it's that. Yeah.
Exactly. Yeah. That's fine.
Okay.
So as long as I'm sure of what the appellant's position is in terms of the supply figure. That's the crucial thing from my viewpoint.
Of course.
Okay, thank you. And again, by next Tuesday, Mr. Evans, you've got your hand raised.
Just to confirm, sir, there was matters for Barfield Road are online, and I'll send a link to Mr. Dodd as we speak.
Thank you. That'll be very useful. Okay, thank you. Is there any more questions in terms of what we've just discussed? Firstly, Mr. Williams.
No, sir, nothing for me. Thank you.
And Mr. Easton.
Not on that, so I've got a point about timetabling, but that can wait.
Okay. Well, I was actually going to move on to timetabling next, so I'll maybe start the ball rolling, and then obviously we can discuss this. Obviously, look at the timetable that I included. Well, on Tuesday when we were in Braintree as such, and the time estimates which have been provided by the advocates. Obviously, we're in the afternoon session now for today, and what I was foreseeing was that the examination in chief would take place of the council's planning witness. Essentially, the time estimate for that from Mr. Williams was 1.5 hours.
It won't be that long, so it'll be about an hour.
Okay. Now, obviously, I think I want to avoid a situation where Mrs. Banks, council planning witness, is in a position of starting a cross-examination today and finishing it tomorrow, ideally. So I was going to suggest whether or not the cross-examination should all take place tomorrow, and then after that, we would need to get through the evidence of Mr. Grist tomorrow as well. Now that should be possible in terms of the time estimates, but I am keen by the time, if you like, we finish close of play tomorrow, that we have got to the point of, Mr. Grist has finished his evidence. Mr. Easton.
So that seems eminently sensible. The other advantage, I suppose, of just hearing Banks and evidence in chief this afternoon is that I can then rationalise my questions overnight, so that I know I've given an up to 3 hours time estimate. I mean, that was out of an abundance of caution. If I can come in, I suspect I will come in underneath that time estimate. So the extra time, experience dictates that one could focus on what are probably going to be the key issues between the parties and not deal with extraneous matters. So that would assist, I think, overall in terms of the timetabling. Okay.
And on that basis, Mr. Easton, do you feel that we would also get through Mr. Grist tomorrow as well?
So I do. I know what questions I'm going to ask him in evidence in chief. I think I've given an up to 45 minutes time estimate. I think that's reasonable.
Okay. Mr. Williams, have any points you want me to raise in terms of the timetable?
No, I understand. So I was hoping we may be able to make a start on cross-examination, notwithstanding your concerns. But given where we are, I don't think there's any point starting only to do half an hour or so today, sir. And so long as I'm entirely agree with you, we might sit a little bit later tomorrow just to finish off Mr. Grist in the nicest possible way, so that we have a chance of finishing next week.
Yes, absolutely. Thank you. Okay, well, before we move on to the calling of the council's planning witness, Mr. Easton, any further points you want to raise at this moment in time?
No, timetabling was the only one I had to raise. Thank you, sir.
And Mr. Williams?
No, sir.
Okay. Well, Mr. Williams, will you please call your witness?
Thank you very much. Could I ask Ms. Banks to come up on the screen?
I'm so sorry. While she's doing that, what would be terribly helpful is to know, at least broadly speaking, what sort of documents we might need. So
Absolutely.
Get the tabs up.
Absolutely. I was just about to go there. Can I just check that Mrs. Banks can hear me and we can hear you, Mrs. Banks?
I can hear you.
And we can hear you. So that's a good start.
Good afternoon, everyone.
We will need, you may not need all of these documents, but it might be worth having them to hand. We'll need, obviously, Mrs. Banks' proof and appendices. We'll need CD 4.2, which is the adopted local plan. We'll need CD 4.1, which is the adopted core strategy. We'll need CD 5.1, which is the emerging section 2 plan. We'll need CD 4.3, which is the adopted section 1 local plan, the shared strategic plan. We will need the main statement of common ground, which is 8.10. We may need the NPPF, which is 8.9. And we will need the design access statement CD 1.3. I can't give a cast iron guarantee that those are all documents, but there's a realistic prospect that they will stick to those. Right. So with your leave and hearing what you said the other day, I'm not going to ask Mrs. Banks to read large sections of her proof of evidence, nor am I going to spend a significant amount of time on either matters that are matters of interpretation of policy, which is ultimately going to be a matter of submissions, nor matters of pure subjective judgment, which is obviously a matter that you're going to take a view on. So that's the framework, and I hope you don't mind me doing so. That should shorten the amount of time. Ms. Banks, sorry, sir.
No, I didn't say no. I've no
You're happy with
comments.
that, right? And given I don't think there are any members of the public here, I'm not going to ask, and we've all read the proofs in detail, no doubt. I'm not going to ask Mrs. Banks to read a large part of the proof, maybe just one or two, and then to expand on it. But Mrs. Banks, if I may introduce you to the inquiry by reference to your page 3 in your introduction. You are Natalie K. Banks, the employer as a senior planner by Braintree District Council.
Yep.
You hold a Bachelor of Arts in Fine Arts and a Master's degree in Town Planning, and you have been a licensed member of the RTPI since 2007. Is that all correct?
Yes.
And you tell us at 1.3 you've had over 25 years in planning matters, largely at Braintree.
Yeah.
Ms. Banks, you have structured your proof so as, first of all, to deal with the main issues raised by the inspector very helpfully in the post-CMC note. And I'd like to start with page 6 and the first of those main issues, whether the proposal will be suitable location for housing with regard to development plan and national planning policy. And I want to start really looking at the existing and emerging development plans. Mm-hmm. Now, can I ask you this? You conclude that having regard to the development plan policy, it's not a suitable location for development. And can you explain, first of all, stepping back from it, what are the key points as to why you say having regard to development plan policy, this is not a suitable location for development?
The key points I consider is the fact that the site is outside of the settlement boundaries, both in terms of the adopted policies and the fact that it has not been identified as a location suitable for development in the draft local plan. Okay, and so you mentioned those as we go through, and I'm going to deal with those in turn. So we'll look at the settlement boundary policies first, and then we'll come on to the spatial strategy points. Okay. And starting with the settlement boundary policies, you start with the relevant policies at 3.2 in the adopted plan, and it will be worth us all having out, please, CD 4.2, and we need to go to page 12 of the PDF. Where we have policy RLP2. And I don't think this is controversial between the parties. Could you just explain
briefly why you say the proposal is contrary to that policy and the context of that policy?
Well, RLP2 is quite an old policy now, but it's part of the adopted local plan, which covered the period 2005 to 2011 and was saved by the Secretary of State. It remains extant, and it states that new development will be confined to areas within town development boundaries and village envelopes. Outside these areas, countryside policies will apply. As I say, this policy remains extant and was not superseded by the core strategy or the Section 1 local plan.
Okay, and the policy we can see contains a number of exceptions. First of all, countryside policies, and secondly, exceptions for affordable housing schemes.
Yeah.
Do either of those exceptions apply to this particular proposal?
No, there's been no case put forward for affordable housing or for an agricultural workers dwelling.
And when you say agricultural workers dwellings, that's one of the examples of the countryside policies which may be an exception.
Yes, sorry, yes. Yeah.
Thank you. And I take limited time on it because I think there's common ground, there's a conflict with that policy. We then move on, please, and you do tell us at 3.3 of your proof to the core strategy.
Yeah.
And that is CD 4.1, please.
Yeah.
And before let's just wait for the everybody to get there. But if we look at 4.1, page 65 of the PDF. Sorry, it's not page 65. So 65, internal 65. It's page 67 of the PDF. Wait until everybody to get there. We can see that's policy CS5, and it tells us their development outside town boundaries, village envelopes, industrial development limits will be strictly controlled to uses appropriate to the countryside. It tells us why it does so, in order to protect and enhance landscape character, etc. Again, your views, please, as to whether this proposal is consistent or otherwise with that policy.
Again, this proposal is inconsistent with this policy because the site is outside of any development boundary. And as such, in our view, it would fail to, or it can't be demonstrated that it would protect and enhance the landscape character and biodiversity and diversity of the countryside because it's an in-principle approach to, what's the word? To seeking to, protect the countryside.
And just on that, is it being suggested, as you understand it by the appellant, that this is a residential development of this type is a use appropriate to the countryside?
I don't think it is. I think the appellant is accepting that the development or the proposal is contrary to CS5. However, there are other material considerations that the appellant considers should put aside this policy.
Yeah, we'll come to that. So we understand that is the common ground in relation to it. So they're the settlement boundary policies of the existing development plan. And let's then move to the emerging section 2 plan, please, which you address at 3.8 of your proof of evidence. And we need to go to CD 5.1. And within that, if we go to page 33, we have policy LPP1 there, as it was in the version that was submitted for examination. Can you just explain to the inspector how it's proposed by way of main modification, this policy is to be slightly amended?
Yes, main modification 10 has changed the wording slightly, and in the draft policy, it basically states development outside development boundaries will be strictly controlled to uses appropriate to the countryside, etc. However, the main modifications propose changing strictly controlled to confined.
And as you understand it, was that a change of substance? Or was it a change of the language to clarify what was being intended to apply?
I think it's a change of the language.
And your views, please, on whether the proposal is consistent or otherwise with this emerging policy LPP1.
No, I don't believe it complies with that policy. I think this policy takes a very similar view to the other two policies in terms of steering development to development boundaries rather than in the countryside.
And obviously it has, of course, the exception within it to uses appropriate to the countryside, but the same question in relation to our CS5. Any suggestion by the appellant that this an exception to LPP1 applies in this case?
No.
Okay, thank you. Now, what you tell us at 312 onwards in your proof of evidence, that's pages 8 and 9. In particular, at 314 and 315, you tell us two things. First of all, you tell us at 314 that the development boundaries in question have been reviewed as part of the evidence base for the emerging Section 2 plan. And indeed, the plan itself tells us that. And just help me with this, please, if you may. There have been some proposed amendments to the development boundaries, but is it suggested that this site would be included within the development boundary of High Garrett?
No, I mean, this site was put forward in the call for sites, but was rejected by the local plan subcommittee and not adopted as an allocation, as it says in my proof.
And what you tell us at 315 is that the council is seeking to meet, indeed exceed current needs, with a surplus of just over 14% during the period of the plan. And the period, do you know the period of the emerging plan?
It's up to 2033, 2013 to 2033.
And so, can you help me and the inspector with this? Why, when considering the weight to be given to the settlement boundary policies, why is it important to have regard to the fact that the boundaries have been updated as part of the emerging plan? The plan seeks to meet, the emerging plan seeks to meet housing needs in full. Sorry,
I don't quite.
Sorry. When you're considering the weight to be given to the settlement boundary policies that we've looked at, why is it relevant that the boundaries have been reviewed as part of the emerging Part 2 plan, and the plan seeks to meet, indeed exceed, housing needs in full?
Well, we've given due consideration to the site and for inclusion as requested, and taking on board all the other works and the revised boundaries that we've been looking at. This site is not required to meet our housing need.
And in terms of the development boundaries coming forward under Section 2 plan, what is at least the council's position? Is it the council's position as the, what is the council's position as to whether the revised boundaries are sufficient or not to meet the current housing needs?
As far as we're aware, yes, they do.
And you'll be aware of the main modifications that were published last week. A note mentioned from Emma Gooding, the head of planning, in relation to that. Just a few questions in relation to that. You'll have seen from that the examining inspectors have approved for consultation those main modifications. Was there any suggestion that LPP1 should be deleted, that the settlement boundary policy shouldn't apply at all?
No. No. And the only modification to it is the one that I've already said.
I think actually there is actually, for clarity, a few other wording changes, but Mr. Easton's got his hand up.
Mr. Easton?
Yes, it was only this, as I didn't quite follow the questions. Was there any suggestion that LPP1 should be deleted? By whom?
By the examining inspectors. The examining inspectors approved the main modifications for consultation, Was it suggested in their main modifications that LPP1, which was put forward by the council, should be deleted as a main modification?
Understood. Thank you very much for the clarification.
Thank you. And as far as you were aware, Ms. Banks, is there any suggestion from the examining inspectors that further sites would need to be found in order to meet the needs until 2033?
No.
Okay. Now, just still on settlement.
Everything's frozen. Oh God.
Oh, Ms. Banks, we can
pull the plug out.
Ms. Banks, we can hear you.
Yeah.
I don't think Mrs. Banks can hear us.
Oh, that would have to happen, wouldn't
I will
it?
see if I can.
Oh, it's back again.
Can you hear us,
Hello?
Mrs. Banks?
Yes.
We could hear you throughout. So if you can't hear
Don't be
us,
frozen.
can you hear us now?
Mr. Williams, Mrs. Banks appears to have frozen and I
I
can't
didn't
hear her.
touch anything.
I can hear her now, but not now. Mrs. Banks is frozen.
Yeah, she's moving on my screen. I can hear her, but she can't hear us. I'm going to contact her if that's okay by WhatsApp.
She's still frozen on my screen, Mr. Williams. If
Yes. Okay, she may need to log back. You're on mute now, Mr. Banks.
That better?
That's better, right.
I didn't pull the plug out, I promise you.
Well, I'd be worried if you did during examination in chief. I mean, during cross-examination, I can understand you'd be tempted sometimes. But so sorry, we had gotten through the questions in relation to LPP1 and where it's heading and what changes may be needed or otherwise to it. I was just moving to a separate question. Did you have anything further to say on that, Mrs. Banks, or are you happy for me to move on?
I'm happy to move on.
So, did you get a full note of the answers?
I did, Mr. Williams, yes.
Thank you. Please do let me know, sir, or Mr. Easton, if Miss Banks does freeze, because throughout that, I could see and hear her, so I don't understand what was happening then. Ms. Banks, a further question on settlement boundary policies. The appellant suggests that somehow there's an in principle conflict between the policies of the NPPF and having a settlement boundary policy. It appears to be, whether needs are being met or not. Could you just help us with your views as to whether there's an inherent conflict between settlement boundary policies and the policies of the NPPF?
Well, whilst the NPPF, it doesn't specifically refer to development boundaries, paragraph 119 states that planning policies and decisions should promote an effective use of land in meeting the need for homes and other uses, whilst safeguarding and improving the environment and ensuring safe and healthy living conditions. Strategic policies should set out a clear strategy for accommodating objectively assessed needs in a way that makes as much use as possible of previously developed land. In my view, development boundaries are in line with the NPPF's overarching objectives, as in paragraph 8, criterion C, which states to protect and enhance our natural built and historic environment. This suggests that land is a resource that should be carefully managed, and I don't understand how else you would do it without development boundaries.
And sorry, Ms. Banks, you had cut in. Do you have anything else?
That's all right. I was just going to say that protecting the countryside is also something that's recognised at paragraph 174B, which states that planning policies and decisions should contribute to and enhance the natural and local environment by recognising the intrinsic character and beauty of the countryside. So they are regularly
Go, Karen.
They're regularly employed in post NPPF plans and as a method for directing growth whilst meeting housing needs.
Yes, I was going to say that your experience of development plans, Mrs. Banks, after the NPPF came in, are settlement boundary policies an alien concept in your experience?
I don't think so. No, I don't, because I don't think the NPPF ever meant a free for all to to deliver the housing need according to the nation.
And so, Mr. Banks, if a plan or an emerging plan is seeking to meet its needs, indeed exceed its needs in full, do you see nevertheless any in principle conflict with policies of the NPPF of having a settlement boundary policy of the like in LPP1?
No, I don't.
Thank you. One further point I want to comment to about LPP1 and the settlement boundary policies is that the appellant appears to suggest there's some tension between particularly LPP1 and SP3, and I will address this primarily in my submissions in closing, because it really turns on a matter of interpretation of SP3. But what Mrs. Banks, you say at 3.6 of your proof is that policy SP3 established a high-level spatial strategy as a whole, with much detail to be provided in Section 2 plans. It's the Section 2 plan which establishes the spatial strategy for the area and which allocates development to meet the housing requirements. Can you just help us, if we take out the Section 1 plan, CD 4.3? I'm sure the inspector's familiar with it, but perhaps by reference to the introductory section, could you just explain the context for the Section 1 plan and what it sought to achieve over what area?
Sure. I mean, the background to Section 1 plan states or indicates a Braintree District Council, Colchester Borough Council and tendering have agreed to work together on strategic planning matters across their areas, collectively known as the North Essex Authorities. Paragraph 19 of the introduction to the plan makes it clear that authorities have agreed to come together and prepare a common Section 1 local plan because of a shared desire to promote sustainable growth strategy. And central to this effective delivery of planned growth, particularly housing and employment, with the necessary supporting infrastructure is completely central to why we have this plan. And paragraph 112 affirms that the strategic 1 plan of the local authorities plans reflects the duty to cooperate as it concerns strategic matters with cross-boundary impacts in North Essex. Section 2 of each plan contains policies and allocations addressing authority-specific issues.
And the inspector can read that at his leisure, and obviously that's a matter I'll address in submissions. But your understanding, Mr. Banks, if I may, about first of all, the area over which the Section 1 plan applied. It was a shared plan applying not simply to the district of Braintree, but also Colchester and tendering.
Yes.
And within that, what type of matters was it concerned with?
Well, it was large-scale strategic issues, economic growth, infrastructure, and housing are the main things.
And in terms of the strategic issues, what was it seeking to do? What was it seeking to do in relation to the Section 2 plans that were then the individual authorities are now bringing forwards?
Well, in terms of Braintree District, the strategy seeks to address growth via urban extensions, with Braintree Town being the largest service centre in the district. The other main focus for development would be the A12 corridor, with the main town of Witham and service villages key service villages of Hatfield, Peveril, Kelvedon and Fearing. with other parts of the district. Housestead will be having as the other main town in the district, but that will have smaller allocations to reflect a more local need, with the other areas being graded as necessary.
And I think, Mr. Banks, you're making reference there to section 3 of the plan. It's page 20, the spatial context.
Yeah, sorry. Is that not what you
right.
asked? I beg your pardon.
And could you just, if we could just turn to page 20 of the local plan, the section 1 local plan, and 3.2, I think you were making reference to 3.3 and what it says about the strategy for Braintree. But can you just help us with what 3.2 tells us about what the section 1 plan does and what the section 2 plan
sorry, yes.
does?
Right, the section 1 local plan would deal with strategic matters, basically to contribute to maintaining and enhancing a well-connected network of sustainable settlements across North Essex. The majority of settlements in these areas will be addressed in the second section of the local plan, dealing with each authority's areas. It's relevant that the spatial context of the North area is as it relates to the main settlements and strategic scale new development.
And so, if we then, that's the context for the policy, and we then turn to policy SP3, which is the spatial strategy for North Essex as a whole. And
oh yes, I see what you mean.
At SP3 at page 21, are you there, Mr. Banks?
Yeah.
Existing settlements through the principal location for additional growth, and we've seen what existing settlements they're talking about. Development will be accommodated within or adjoining settlements. That's the passage the penalty to highlight, according to their scale, sustainability, existing role, both within each individual district and where relevant across the wider strategic area. Help me with this, Ms. Banks. How and through what mechanism is that development to be accommodated?
Through the section 2 local plan, each local planning authority will identify a hierarchy of settlements when new development will be accommodated, and that is what Braintree District Council has been doing in its section 2 local plan. And
you're reading there, Mrs. Banks, from the 3rd paragraph of SP3, aren't you? So that then tells us that it's a section 2 local plan which identifies a hierarchy of settlement where new development will be accommodated according to the role of settlement, sustainability, its physical capacity and local needs.
Yeah.
In light of that then, and I know we know what the appellant's got to say about the within or adjoining settlements.
Yeah.
But to what extent, in your view, is SP3 directly applicable to the circumstance we find ourselves here on an unallocated site on an appeal?
It's not applicable because the site has been looked at as under the section 2 local plan. And it's not, we have not identified it as an area for growth. I can't really say any clearer than that. We've SP3 clearly is an overarching strategic policy telling each local authority within the group how to deal with its strategic planning. But under section 2 of the plan, or under your section 2 plan, that's when you then begin to do your sort of more individual allocations and what you need for your particular district. High Garrett has been looked at as part of this process, and whilst a few minor alterations are being made to the settlement boundary, it's not identified as an area for growth. It has now been graded as a 3rd-tier village, which I think we might come on to, well, as it's set out in my proof, but sorry.
That's okay. That's sort of the finish of the first point you had on the settlement boundaries. Let's move to the sort of secondary point you had about that High Garrett isn't the focus for development and spatial strategy. And you make that point in a various places in your proof, 319 and 320, for example. We might have to pick up the emerging section 2 local plan, which is CD 5.1. And obviously we have to read this, so with the proposed main modifications, which were published, of course. But could you help us with this, Mrs. Banks? Why do you say in your proof that High Garrett is not a focus for development in the spatial strategy of the emerging plan?
Because of its lack of ability to provide residents with day-to-day facilities that they would need. For one thing, it's basically the section of High Garrett that the site is in, but in particular is a section of ribbon development. There are no facilities in the village for day-to-day needs. People have to go to the next largest settlement, which is High Garrett. Therefore, we don't feel it's a location that we would identify for growth.
Ms. Banks, just pausing there. Just two things. First of all, I think Mr. Easton looked up eyebrow raised when he said next largest settlement. He said next largest settlement, High Garrett. You were talking from High Garrett. I think.
Yes, sorry.
I think it's fair to say you may have misspoke there.
Sorry, I beg your pardon.
Where did you say where you tended to say they need to go for their day-to-day needs?
Yes, they would need to go for some of their day-to-day needs to Bocking, which, although a higher settlement, is not still would not provide everything that they would need for day-to-day needs.
Okay, and we'll come on to the specifics of the day-to-day needs and the accessibility on our next issue. So just park that thought. What we're looking at now is the strategy as it's emerging for the area. Let's start by going to the spatial strategy within the emerging plan, which is at paragraph 5.13 of the emerging plan at page 32 of the PDF. And tell me when you're there, Banks.
.32, did you say?
Page 32 of the PDF. It's internal page 28.
Oh. Yeah, I'm there.
And just help us with this. It tells us there the broad spatial strategy for the Braintree district to concentrate development on the town of Braintree. Plan New Garden Beach is obviously deleted as main modification because the one in Braintree district is not coming forward. Witham and the A12 Great Eastern Main Line corridor and Halstead.
Yeah.
Is there any suggestion that, as part of the broad spatial strategy, development should be proposed in High Garrett?
No.
And help us in the above the spatial strategy, there is a settlement hierarchy. And we can see at the top of the spatial hierarchy are three of the towns, Braintree with Bocking and Great Notley.
Yeah.
Can you help the inspector, we can go into it if you want, as to, there's been a proposed main modification approved by the inspectors for consultation that High Garrett is included within the spatial strategy, within the third tier. Is that right?
Yes.
And can you just help inspector with what is said within the emerging plan about third tier villages and their appropriateness or otherwise for significant development?
They are considered, well, they are the smallest villages in the district and lack most of the facilities required to meet day-to-day needs.
And sorry, we need to, Ms. Banks, you need to, when you're reading from the section, we need to tell everybody else where we are. I think that's 5.10 of the
5.10, beg your pardon.
5.10 of the Section 2 local plan. And what does it say about the likelihood or otherwise of the test of sustainable development being met in such villages?
Well, it says that they will not normally be met.
And what about the next paragraph, the countryside? Obviously this site does fall out with the emerging southern boundaries and in the countryside. What does the plan tell us about the approach to development in the countryside?
In order, well, they're considered to be countryside, and in order to protect them, the development will normally be restricted.
And that's obviously consistent with the settlement boundary policies that we've looked at. Okay. Thank you. Just fine on this first main issue. We'll come to weight later when we get to your balance, but your conclusions, please, at 320 and 321. If you could just read those paragraphs of your proof, page 11, 320 to 321.
The proposal is in direct conflict with adopted policies RLP2, C5, CS5 and emerging policy LPP1. It is also contrary to the spatial strategy established in SP3 and contained within the emerging Section 2 plan, which seeks to direct residential development to within updated development boundaries and to settlements which are more sustainable than High Garrett. And overall, taking the above matters into consideration, it's not considered that the principle of the location of this development is suitable for housing development, contrary to the aforementioned policies and the development plan as a whole.
Okay, thank you, Mr. Banks. And we're going to move on to the second main issue, the accessibility of the site to local services. And you deal with that page 11 onwards of your proof. I'm not going to concern you, the inspector, with development plan or national policy on this, which I don't think I'll ask Mr. Grist about it. I don't think there's much between us in relation to that. But I'll start with your analysis, which starts at 4.6 of your proof. And you start by considering accessibility by foot, walking.
Yeah.
And could you just, stepping back from it, summarise the council's position as to whether this is an accessible location by foot to facilities for day-to-day needs?
Right. The evidence put forward by the appellant is indicating that the site is within an acceptable walking distance of Bocking, which is, as I said before, is the nearest larger settlement that contains some of the needs that might be required, such as a local shop, a school, nursery schools. And the statement of common ground at Appendix 3, CD 8.10, sets out.
If I could pause you there, Ms. Banks, sorry. That's the appellant's position. Do you agree with their proposition that Bocking in the facility is such that they are is within an acceptable walking distance of this site?
No.
And you were going to take us to the statement of common ground, 8.10, because we've agreed in Appendix 3, helpfully between both parties, and I'm grateful to the appellant for cooperating with this. Appendix 3 is the distances to local facilities and services, walking distance from the centre of the site. So if we could take that plan up, please. And at the same time, in your proof, so we have that up as well, and then we have your proof of evidence at page 15.
Yeah.
Where you set out a table extracted from the Institute for Highways guidance, providing for journeys on foot, which both you and Mr. Grist refer to, and you set out the desirable, acceptable and preferred maximum distances for a variety of facilities.
Yes.
I'm going to ask you just to comment on that in a moment, but first of all, before I do, to what extent does High Garrett itself, in your view, provide facilities for day-to-day needs?
In my view, it doesn't. The facilities that it has got are not usually things that you would require for day-to-day needs, for instance, as an MOT garage or a craft gift shop centre. I mean, they're not, although they're referred to, they're not matters, they're not sort of facilities that you would need for everyday use. And
just to be clear, I'm sure the inspector saw this on the site visit, but it says their High Garrett service station. Is that one of those service stations that's got a sort of Tesco's Express or a Waitrose or something?
No, it's an MOT service station.
Thank you. And therefore, we've got to look at booking for the facilities for day-to-day activities. And just, you've dealt with this in your proof to some degree, but just you give the inspectors the headline points as to where those facilities fall in relation to the IHT guidelines.
Yes, I mean they're giving the acceptable distances being the the maximum distances set out in the table as being acceptable rather than the actual desirable or acceptable. Sorry, please forgive me. I'm so nervous. I haven't done this for a very long time.
Don't worry, Miss Banks. Take your time. Really take your time. Don't worry about it.
Sorry.
It's certainly not a trial in that way. The inspector needs to hear your evidence. Take your time.
Right.
And,
what the appellant
what I was asking was about the IHT guidance, and you were saying that the appellant made reference to the preferred maximum. You're making a point about that. Perhaps you want to develop that.
Yeah, the point I'm making is they're stating that the preferred maximum is an acceptable walking distance. But if you take, the distance for walking to school with 500 metres being acceptable and 1,000 metres, sorry, that's wrong again.
500 metres desirable and 1,000 acceptable.
Yes, with a maximum of 2,000. Well, Scallyrags Nursery is at a distance of 1,899. Agnes Day Nursery 1,416. Bocking Primary School 1669, which puts schools and nurseries way above the desirable and acceptable distances and just within the maximum.
And what do you say about that's obviously concentrating on nurseries and schools. What do you say about what that should tell the inspector about the acceptability of those distances for day-to-day walking?
Well, it only really gives an indication that people would make the journey one way and not have to go home again, and that they would be sort of, they wouldn't have sort of doing that sort of walk with young children is probably not reasonable, and it's probably overly optimistic to expect them to walk that kind of distance.
And you've done the walk, Mrs. Banks.
Yes, I have.
In your view, is that something that a mother or father is likely to do on a regular basis with their young children, dropping them off at school by foot? I
don't believe so, no.
And in terms of then the accessibility to retail and convenience shopping, for instance, help us with that. What's the closest retail facility for day-to-day shopping facilities?
Well, the closest one is the co-op, and as can be seen there, that sort of people tend to walk about 200 to 400 metres as desirable and acceptable distances, with a preferred maximum of 800. This is well beyond that.
The co-op being 2,230 metres degree distance away.
Yeah.
And what your view about whether somebody would decide regularly to walk to go and get their daily shop or weekly shop to the co-op?
I think it's unlikely, A, because of the distance of from the site to the co-op, and B, the co-op is only a fairly it won't provide all the everyday needs for a modern family, so they would have to go beyond booking anyway. But I think it's unlikely that they would walk there and walk back again with bags full of shopping, or just to go and get a pint of milk. It just goes beyond what is seen as desirable or acceptable in the IHT guidelines.
Yeah, you've got 4 foot 15. You tell us your conclusions there. The primary school is well above the acceptable, and most of the maximum. Most of the other facilities are well over the acceptable maximum, whether applying town centre criteria elsewhere. And they don't consider that Bocking is a reasonable walking distance on a day-to-day basis.
Yeah,
that's based on distance alone, and at 416 onwards, you come on to consider the nature of the walk.
Yeah,
and perhaps we can sort of step back from this, and the inspector was seeing the site the other day, and I don't know whether it took a walk to Bocking, but could you help us with the nature of the walk, most direct walk to Bocking, and whether it's an attractive route for pedestrians?
In my view, I mean, the distance and the sort of the ambiance, for want of a better word, of the walk from the site to down into Bocking is not pleasant. Although there's no allegation that it's unsafe. This is an arterial road with a speed limit of 40 miles per hour. It's fairly busy, and there are large vehicles that pass through on a regular basis. The perception when walking along the pavement, which you would have to cross the road from the site onto the east side, is that you're very close to the traffic. The pavement varies in width and varies in conditions, and it's quite a long walk along that east side of the road before you get to the Church Street junction, where you would obviously have to cross the road again. And then when you get to the top of Church Road, you've got to cross over again because there's no footpath on the northern side of the road there. So
can I just ask, would you have seen that as part of your site visit, the crossings that you had to do? Or do you need some clarification as to where those
No, Mr. When I did the just again, both advocates again guest benefit. When I did the unaccompanied site visit, I walked on the site via LVA viewpoints to Bocking, down as far as the co-op and the nursery just beyond the co-op, and then I walked back along Church Lane and then back up the A131 back to the site. So yeah, that's essentially the route I took in terms of what I did on foot. Anyway, I went to other places by car, but in terms of what I did on foot, that's essentially what I did.
So that's very helpful clarification. I don't then need to point out where there's crossing points where you would have seen those. Thank you very much. So that's helpful. And so your view, Mr. Banks, in relation to taking account of the distance and taking account of the nature of the route, as to whether walking is a realistic option for the majority of the future occupants of this site on a regular, even semi-regular basis?
I don't believe it would be so. I mean, there are, public footpaths around the fields that lead into the village, but people who are taking children to school or want to go shopping are unlikely to walk on such paths because they're unsurfaced. It's also an even longer route to go that way, but the distance, the time it would take to walk down to the facilities and the actual nature of the walk, I think would preclude people from making that as a first choice. They are more likely to drive, for matters of convenience. Yeah, sorry, I'll leave it there.
Thank you. Moving to cycling, you set out your points of 422 to 425 of your proof. I don't think you need to read those, but again, can you summarise? Mr. Grist, I think, he doesn't say everybody would regularly cycle or lightly cycle. He recognises the nature of the A131 and says that experienced, confident adult cyclists may cycle. Your view, please, as to how realistic that is for at least the majority of future occupants.
I think it's very unrealistic. Cycling along that, as I say, that road, there is a perception of speed. It's a busy arterial road. You would have to, if you wanted to go to Bocking, you would have to make a right turn across traffic. If you wanted to go onto the east side of Braintree or through the town centre, you would have to cross the roundabout connecting the A131 to the A120 and Broad Road. I just don't think it's something that people would do to commute or to do their shopping or take their children to school. I just don't see it as being a realistic option.
425, you of your proof at page 18, you draw upon the 2011 census data.
Yeah.
What do you say that tells us empirically about the realistic nature or otherwise of people in the Bocking North Ward, at least using cycling regularly?
Well, I think that speaks for itself. Is if there's only 2% of people in the Bocking North ward, and that includes not just High Garrett, but the rest of that ward, it speaks for itself that people do not choose to cycle very much, you know, around this area.
And what's the main detraction, as it were, for if you were going to, say you were going to wanting to go to the Springfield estate, or you want to go to the railway station in Braintree? What is the single biggest deterrent for doing so if you were an occupant of this site in the future?
Well, it'd be crossing from the east side of the road if you were heading south across to go down to Church Street if you went that way, and then it's a quite a, you know, a convoluted journey. It's not particularly direct.
Okay, and then public transport and buses, and you accept that there's a reasonable regular bus service and that there are bus stops outside of the site. You express a slight concern about people using the bus travelling south towards Braintree, at least if they've got children or like. What's your concern there, Mrs. Banks?
Well, it's the logistics of say you've got one or more children and you've got to get them across that road, even with a crossing there, would be difficult, especially in all weathers. It's going to be far more attractive to put your children in the car and drive them there. Sorry, I was going to say, it's not, you know, most people are going to be unlikely to take a short bus journey down to Bocking to take their children to school. It's much easier to get in the car. Sorry.
Mr. Grist says, well, the traffic travels in, I think he says, platoons. And so there are gaps that you can get across the road. You presume you've crossed the road to access the appeal site, have you, on a number of occasions?
Yes.
And how easy, if you wanted to get the bus running south and you had some children with you, how easy would that be to do?
I don't think it would be particularly easy. You know, I think it would be quite hair-raising, to be honest.
You then come on to deal with previous decisions, and there are two types of those. And we'll deal with the first one. For 28, you make reference to the Thistlefield Road decision, or sorry, the Thistlefield decision, which is the field immediately to the south of the appeal site on A131.
Yeah.
You cite from the inspector saying that although there's a reasonable bus service, the walking distance from the site to facilities in Bocking would be prohibitive. What are your views as to whether that judgment is, in your view, an accurate or an inaccurate judgment?
I completely agree with that judgment. It aligns with my own feelings, which or that I put into my proof, which I wrote before this or started writing before the judgment was received. It is a very busy road for cyclists or people walking. From that point of view, I do not foresee that people will use cycling, walking, or catching the bus from that site to get wherever it is they need to go.
Thank you very much, Mr. Banks. We'll move on to the next topic. So I'm assuming you're happy for us to push on without having an afternoon break. You don't want to. I'm not going to be much longer.
No, I think given the where we are, Mr. Williams, and the timings, etc. Yeah, if you can just carry on, please.
Yeah, it's just imagine it's going to be about another 15 minutes or so. But oh, sorry, there was one thing I wanted to pick up with you on the accessibility point, and it's something you addressed at 429 of your proof. What the appellant points to a number of schemes in the vicinity of the site where the council have granted planning permission for them, and say, well, the council taking an inconsistent approach here to the question about whether this area is accessible or not. Can you help me with this? What relevance? Sorry, what size of dwellings, or how many dwellings were being proposed on those 3 sites?
There's a total of 13 over 3 sites, with the maximum site, the largest site, having 8.
And what relevance, therefore, does that have, in your view, to whether this site for 37 houses is a sustainable location?
In my view, they're a total different magnitude to what's proposed here. This is a development of some significance, and I don't believe these decisions provide any precedent for allowing a development of this size. They were obviously they were judged on their individual merits at the time and were not significant developments.
And why is the question about whether it is a significant or not significant development of relevance when you're considering whether the location is a sustainable one or not?
Well, the policies in the spatial strategy in the Section 1 plan indicate that significant development should be I can't think of my words today, should be put forward to the strategic sites and the sites identified in the Section 2 local plan. And
help me with this. The NPPF, if we pick up the NPPF, maybe 8.9 of the, we go to paragraph 105 of the NPPF.
Yeah.
Please.
Yeah, it states that planning systems should actively manage patterns of growth in support of the objectives set out in the 104. Significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes.
And pause there then. So is national policy saying that all developments, including mine development, need to be in sustainable locations, or does it draw a distinction?
I think it draws a distinction. It refers to significant development being, located to such put forward to such locations, rather than, the odd house here and there.
And your view, please, as to whether this proposal for 37 homes constitutes significant development for the purposes of Para 105?
I think it does in the meaning of Para 105.
Thank you. Right, now we can move on to the effect of the character and appearance of the area, which you deal with at page 20 onwards in your proof. And I think what it might be helpful to have out, of course, the inspector has seen the site, so it's very helpful to know that, but it might be helpful to have out the design and access statement, CD 1.3. Because at page 9 of that's the PDF page 9, page 8 internally, there is a helpful aerial photograph. If we have that out and we then turn into your proof to paragraph 5.8.
Yeah.
You tell us there that the western side of the A131 within High Garrett has a very different character to the eastern side. Western side remained large and developed other than the development of Grove Field and a few detached houses immediately adjacent. Can you, by reference to the aerial photograph and what, of course, the inspector has seen on the ground, explain how the character of the eastern side of the A131 differs from the western side in the vicinity of the site?
Well, as you can see, the eastern side is quite densely developed, and the western side, save for Grove Field, is countryside. It provides sort of a rural edge to the settlement of High Garrett, and a green framework and a relief from the busy road travelling through.
And paragraph 5.9, you in effect say that the appeal site's got two functions in landscape terms in your view. Can you help us, please, with what you say the functions are that the appeal site plays in landscape and character, which are of relevance or materiality.
In those terms, I mean, it marks sort of a transition from the countryside as you're heading towards the main town of Braintree, on the left-hand side, the western side, if you're travelling south. But it also provides a setting for what is there of High Garrett, in providing sort of a green framework.
So let's just take those 2 points and develop them. If you're travelling south, you were saying that it gives a different sense as you're travelling down towards Braintree.
Yeah.
Could you just expand on that? What do you mean different sense to what?
Well, it marks a transition, I think, from going from sort of wider countryside to the more sort of urban centre of Braintree. And
so, help me with this. Is the character of High Garrett materially the same or materially different to that of Bocking or Braintree?
Yes, because it is basically a section of ribbon development that's developed from the original core of the village, which is further up north. That developed at a different time to where we're in now, and that western side has largely remained undeveloped for a very long time, and in my view does form the setting for what built development is actually there now.
And so just developing on that, what type of character, what type of setting does the site help High Garrett to have? Yeah, it provides, it delineates the sort of transition from the sort of the urban ribbon type development on the eastern side to the countryside on the west. And let's say Bocking and Braintree have got their own characters. Is High Garrett's character the same or different to Bocking and Braintree? Well, it's different because it's not urban. It's and it's neither countryside in some respects, but it sort of is a transition between the two. Yeah. And if this site were developed for 37 houses, let's take this in stages. How would that affect the setting of, in your view, of High Garrett? Would it have the same rurality that you refer to in your proof or not? Well, no, it wouldn't. You would be creating a development at depth there, which would have the effect of hemming in the development that's already there. You've got this sort of nice open aspect. I appreciate that there are some trees along the western boundary, but you would lose that. You would lose that sort of green space, which is sort of part of that transition from High Garrett to Bocking. I appreciate. Sorry. Sorry, you wanted to say something else? No, it's fine. Carry on. And you just looking at the inspector will have seen it on his site visit, but if we pick up your appendix 11, you have some photographs of the site obtainable from the footpath to the east of the A131. And as you know, there are some trees on the eastern and western boundary, but currently, how is a receptor walking up that or driving up the A131? Are they aware of the greenery of the appeal site itself? I appreciate that there is a hedge line along the western boundary of the site itself. You do get glimpses towards the wider countryside as you pass further down towards the Grove Field, but you can also see behind Grove Field into the countryside beyond. So that's beyond the western boundary. And then what about the appeal site itself? Is the undeveloped nature of the appeal site, is that perceptible to those receptors? I think so. I mean, I think it does form part of the setting of that section of High Garrett. And then going back to your proof then, please, that 510 onwards, you make reference to the Church Street decision, and you point out that the inspector there was granted permission for the smaller number, the 265 unit, as opposed to the original 300 proposed. So Mr. Easton will know this site well. If we look back on the design and access statement at page 8, can you just highlight for the inspector's benefit the field that the inspector in that case thought it was important enough to refuse permission for the 300 units to keep open? Which field are we talking about?
We're talking about the field on the northern side of Church Road at the corner of the junction with the A131, which sort of lines up directly with our site. If you were looking north, as it were, it sort of runs parallel. Does that make sense?
And why do you say that is of relevance to the question about whether this site on the west side of the A131 should be developed or not for housing? Sorry, Mr. Easton.
I think the inspector recognises.
Thanks, Mr. Easton.
Sorry.
Yeah, sorry, sir. This is, I suppose, one disadvantage of a virtual inquiry, albeit that we could share screens. I know which piece of land Ms. Banks is talking about. I just want to be absolutely clear that everybody else who's listening, the inspector above all, knows exactly which piece of land was removed from the Gladman scheme, which is.
Yeah, my understanding from reading the evidence, Mr. Easton, it's the field on the corner.
Yeah.
Yeah, correct. As long as you understood that point. So
I'm great, Mr. Easton. Thank you for that. You're absolutely right. It's one disadvantage not being able to hold up a hard copy.
I'm sorry, I keep pointing to it, and that's not very helpful. So I apologise.
Oh, I think we're all on the same page, and thanks, Mr. Easton, for that clarification. Yes, I was going to say, what's the relevance of that, in your view, to the proposal to develop this site for a residential development?
I think he felt it was important to keep that site, to keep development back from that field because of the role it plays in terms of the corner of Church Road and the rest of High Garrett. That's providing a sort of a green edge and a separation from the character of High Garrett and Bocking.
You helped me earlier with the question about what would happen if to the character of High Garrett if this is proposed in terms of its rurality. And if you're right, and if the inspector agrees with you, and that this does have an adverse effect on the rurality of the character or the character of High Garrett, what does that do in relation to the transition point as to the separate identities of High Garrett and Bocking and Braintree?
Well, it erodes sort of the green spaces that form part of the townscape that exists at present.
Now, you addressed at 512 to 513 the capacity study, and as did the officer's report, and it accepts that the capacity study concluded that the appeal site and the site to the south had a medium capacity development, and it said it would be a natural extension to High Garrett. What do you have to say about that study and the impact on your judgments here?
I think whilst they've made the case that it would have medium capacity, I think it misses the point of the fact that the land does form part of the townscape of the local area, and the study doesn't necessarily it's there to just establish relative capacity. It's not there as an absolute conclusion that the site should be developed. The council has looked at this site during the review of the boundaries and the preparations of the draft section 2 local plan, and this site has been put forward and discounted.
And just to help me, this, you said about the relative capacities.
Yeah, medium capacity.
Thank you.
Sorry.
And does if that's right and there's medium capacity as opposed to medium high or high, I think the higher ones, does the fact that it has been identified as having medium capacity means that there'll be no harm in landscape or visual terms from developing it?
I don't think it does mean that. It can't do. Because all development has an impact, and the study isn't meant to be the be all and end all for us to draw conclusions from it that development would be acceptable there. There are other reasons why that the council does not consider that developing that site would be acceptable.
Okay, and your view then as to whether there would be landscape or visual harm in this case that has to be weighed in the planning balance?
Yes, I mean, there'll certainly be visual harm in townscape terms, and also in terms of the framework it provides, for the setting of High Garrett. And, in understanding how the other settlements sort of are separate or linked together from each other.
Thank you. Moving on, your pre-housing land supply matters I won't deal with because that's been addressed at some length this morning, but then we'll turn on to the planning balance. And in view of the time, what I just point, you set out at 7:11 to 7:13 the breaches of the development plan that you have identified in light of the matters that we have addressed. And you conclude at 7:13 that overall you consider there's a departure from the development plan and indeed a high degree of conflict with it. And then you come on to the benefits of the proposal at 7:17, and you give housing the 37 new houses and the which are made up of 23 market, 14 affordable. You give that moderate weight given the scale of development in the council's housing supply. Could you just expand on why you give that moderate weight in this context?
It's because of the scale of the development in the rest, sort of looking at the rest of the allocations in the local plan, and the actual amount, the actual contribution it would actually make to our housing supply.
And in terms of the housing supply position, what do you say about the council?
I mean, our view is we do have sufficient housing in our projected supply, so therefore we don't believe that we need this site. Therefore, the amount of housing that would be supplied by that development wouldn't outweigh our other policies of wishing to safeguard this site.
And affordable, Mr. Sorry, gentlemen, escape my name. Mr. The planner for the appellant. I do apologise to
Mr. Murray
Cox. Absolutely, thank you very much, Mr. Chief. And I'll remember it when
he won't be offended. He won't be offended in the slightest, Mr. Williams.
Given I met him in person the other day, I'm deeply embarrassed and I apologise to him. Mr. Murray Cox gives some evidence and indicates that there's a shortfall in delivery against affordable housing requirements, albeit not in the last couple of years. What do you have to say about affordable housing and what the council is doing to meet that shortfall in the coming years?
I mean, our delivery has been improving and will continue to improve because the council is seeking to make up the shortfall of housing within the next 5 years by applying the Sedgefield approach, which will therefore bring an increase in affordable housing. For instance, for the year 2021 to 22, we are projected to deliver 408 affordable homes without taking account of Section 106 contributions.
So an improving story in relation to affordable housing, albeit we accept that there is a shortfall. And then you give us the weighting for economic benefits and the like, and the inspector's going to have to come to a judgment in relation to those. Mm-hmm. And then we turn to the adverse impacts, and you take the main issues in turn. And just asking you some questions about that. 7.22, you give the locational point, the in-principle locational point, moderate weight in the planning balance, and explain why you give that moderate weight rather than full or significant weight at this stage.
Well, the proposal is located outside the settlement boundaries and is not an appropriate use in the countryside. The breach is significant and renders the proposal at odds with central policies in our existing and emerging plans. However, given the basis that the existing boundaries are drawn, and as a Section 2 plan is still at the examination stage, that's why we're giving it moderate weight.
Thank you. And then accessibility facilities we've heard about, and you give significant weight to the site's unsustainability.
Yeah.
What do you have to say, if anything, about whether that's consistent or otherwise with what the NPPF tells us about locating development in sustainable locations?
Well, the NPPF is quite clear in advising to concentrate significant development in sustainable locations, and in this case, we don't consider that High Garrett is a sustainable location in the meaning of the NPPF. That is why we feel that development should not be granted.
And then you give significant weight to harm and character and appearance of the country, and obviously the inspector will have to take a view in relation to that. Any further points in relation to that point, Ms. Banks?
No, I don't think so. I think it's all in the proof.
If I could just ask to finish by reading 8.1 to 8.4, and I've got one final question.
You want me to read it? Sorry.
Yeah, if you could.
Sorry. The proposed development conflicts to a high degree with the development plan and represents a significant departure from it, as well as being contrary to the spatial policies of the existing and emerging local plans. It would bring about significant harms, not only as a result of the poor accessibility by sustainable modes of transport to the facilities needed for day-to-day living, but also as a result of the loss of this part of the countryside, which clearly plays a valuable role in providing the setting of High Garrett and the approach to Braintree and Bocking. As such, the proposal fails to achieve sustainable development, as it not only fails to recognise the intrinsic character of the countryside, but also because future occupants would be heavily reliant on private transport, contrary to the objective of national and local policy. In my view, the modest benefits of the proposal do not outweigh the breach of the development plan and the harms that the proposal would cause. Furthermore, even if contrary to its case, the council is found not to have a 5-year housing supply, then in my view, the adverse impacts would significantly and demonstrably outweigh the benefits of the proposal. In my view, it therefore follows that planning permission should be refused.
Okay, just the last question on this. If the inspector were to say, well, I disagree with you, Mrs. Banks, in relation to the weight to be given to the housing, and either there's not a 5-year supply or given the overall context that significant weight should be given to the delivery of these 37 houses and affordable housing, how would that affect your view at applying the tilted balance of 8.4? Would it change your view?
No.
Thank you very much, Mr. Banks. Thank you, sir.
Thank you, Mr. Williams. Miss Easton, you have your hand raised.
I do, sir. Thank you. It's only this, that towards the end of evidence in chief, Miss Banks made reference to projected affordable housing completions of 408 in the 2021 to 2022 year. That's not something that appears in her proof of evidence, and it's not something I think we've been able to find for ourselves. It'd be very useful to know where that figure came from. So if it could be emailed to us overnight, so we can have a look at it and so we understand the source of that evidence, then it's something that Mr. Murray Cox could take into account. It's something I could perhaps look at in cross-examination.
Yeah. Mr. Williams, and Mr. Easton actually has effectively preempted one of my questions in relation to that information. So if that, that would be very useful if that information could be provided to all parties.
Yeah, certainly, I can provide the basis for that. Whether we can do it overnight, I can't absolutely promise. I'll try and do it so Ms. Beeson can ask questions, but it will certainly be very good time before Mr. Murray Cox gives evidence.
Okay, thank you.
Yeah, well, the only thing I'd say is obviously Miss Banks has got the information, so I'm not sure how difficult it's going to be for us to have it.
So I understand that. As I understand, it's not in a published form, so we need to provide it in a form as to what completions there have been thus far and how it's been projected up to 408. I can provide that, certainly. I'll ask that to be put in a form into a note so it can be provided to you and to the inspector.
Okay, thank you. Mr. Easton, if any more matters do you wish to raise before I adjourn for the day?
No, that was it. Thank you. Be relieved to hear, sir. And
Mr. Williams?
No, sir. Thank you very much, sir.
Thank you. Well, the time's now 10 to 4. I think it's a suitable point to adjourn the inquiry. So please can the council provide the attendance list of those who have been in attendance today, and we will resume at 9:30 tomorrow morning. Thank you.
So just on that, sorry, just on the attendance list, sir, did you want the attendance list? My understanding was it just those people who are physically present at the office, not that everybody on the virtual, or do you want everyone on the virtual as well?
I think what my preference would be, there is I don't know in terms of whether other virtual events you've been involved with, Mr. Williams, there is essentially like a virtual version of the attendance list, which I think most councils now have a copy of. And basically on there, normally what's listed is there's both main parties and any interested parties that are in attendance. So I'll just simply, wanting because obviously I'm not there in person, so I can't physically under, the old version of the physical list around. So I just simply request the council do that so that, I have a record, my records of who actually is, in attendance, particularly as obviously who aren't actually speaking.
Sorry, my question wasn't clear. So you want not just those who happen to turn up at the council, I don't think anybody has today, but actually those that are present virtually as well.
Indeed, yes. In terms of those, I don't mean people that are just necessarily watching the streaming, for example. I don't mean that. What I mean is people are actually, if you like, in a more conventional sense, or for want of a better word anyway, are either attending the inquiry or observing. Does that make sense?
Yeah, absolutely. Everybody from the Teams meeting, anybody that turns up in person. Yeah. Understood, sir.
Great.
Thank you very much.
That's fine. Thank you. Okay, well, we'll resume at 9:30 tomorrow morning. Thank you.
Thank you.
Thank you.